Handing over the slip upon notice to the other side, my lord.
Just hand over the slip, we'll see.
Yes, grateful.
My lord, may I be permitted to mention one matter, a writ petition, where a vacating application has been filed and affidavits have completed in the last circuit bench. It was advised that both the matters be heard together, the vacating application as well as the main writ petition. My lord, this is extremely urgent and they are enjoying stay since last year to March 2024.
Madam, do you read the what is the instruction from this court? At the time of mentioning, please give the slip. We'll
My
see.
lord, handed over yesterday, but the grounds
Oh,
of
madam.
urgency.
All right. Then I have not taken it up. I have not taken it up.
My lord, I'll mention the grounds of urgency and hand over the slip today again.
Do it tomorrow. Today it's too late. Call out the matters.
Obliged, my lord.
Item number 1.
Your lordship, kindly pass it over for 10 minutes. 1, 2, and 4.
What happened, Mr. Burman?
1, 2, and 4. For this matter, I am appearing on behalf of the CGST. Kindly pass it over for 10 minutes.
Pass.
10 minutes.
Pass. Hmm? 1, 2, 4, right?
1, 2, and 4.
Item number 3.
Yes.
My counsel is on way. Then you can part.
Why at 12? We'll pass it over whenever it comes.
Otherwise, I have to.
Can't fix matters like this, sir. Pass it over.
Item number 5.
No, I'm appearing for the petitioner. Am I audible, my lord? I am appearing for the petitioner. Well, I paid for a leave to file a supplementary affidavit on the last occasions. My junior also.
Not maintainable now.
But at that point, that apart to that point, I leave to prepare and file. I'm for the petitioner. Well, you lordship allow me to file for the petitioner.
You're for the petitioner. Yes,
But
what I'm seeking.
I need to file a supplementary affidavit, but I'm annexing the fake deeds on which the transfer of the record of rights has been transferred in the name of a third party. That you're only on the grounds, you lordship come to why I placing this page 27 of my writ petition. Just
Page 27 of your writ petition.
Page 27. But this is an has your lordship got it?
Yes. What is there on 27?
Page 27 is an order, government order, whereby the Land and Land Reform Department, Government of West Bengal, directed the block land and land reform officers to not to insist against if it is found that the deeds which are the fake on the basis of which a transfer of record of rights has been done, not to insist those persons who are alleging that to prefer an appeal under section 54. Your lordship can that on the basis the other orders also passed by this honorable court in other orders where this honorable court has directed to produce all these things. Those are the fake deeds which are I am alleging, which has been alleged transferred in the name of the third party on the basis of that alleged deed. I have obtained the certified copy of those deeds on which these have been obtained. That only I need to file a supplementary affidavit showing that these are the deeds. I have complained on that, but the documents I have complained that is at page 25, that on the basis of that GO.
Yes,
Only
Mr.
the-
Paul, what, what were you saying?
The specific order has been passed. If you have to kindly comes to page
Yes.
21, Madam.
Yes, that is the specific order.
20 onwards.
Yes.
Madam, this order is appealable, Madam. Under section 54 of the Land Reforms Act. And even if his representation is not considered, the honorable LRTT has the jurisdiction, Madam.
Honorable?
LRTT, Land Reforms Tenancy.
Land. Why should I entertain your writ
Madam,
petition?
only, your lordship, on the basis of that, well, on the basis of the 17th January 2020's GO, which my lord prompted me to make such allegations, and I have got the documents, my lord, the registered deed, a certified copy of the registered deed, my lord,
Sir,
only
you can take all that in appeal also. You don't need
my lord,
to.
on that, my lord, on that score, my lord, let me give some time. The order which has been passed by this honorable court on the basis of the 17th January, which directs the BLLRU to take the cognizance of that on the basis of the 17th January. That orders with not just now with not with me, but I will produce if your lordship kindly give us some time. But the order passed by the honorable High Court on the basis of this GO, where this order has been passed and they have taken the steps to find out what the forged documents are there, and they have taken steps.
That is
That
a-
on.
Mr. Gupta, that is a separate proceeding. Whether the
Well,
documents are forged, not forged, are a separate proceeding.
Yes.
As
well,
far as this order is concerned, you can
No,
bring
no.
that all that before in appellate court also.
These on the basis of 17th 2020 order of the government,
That's all right, Mr. Gupta. I understand on the basis of your 17th January
January
order
2020. Yes, yes.
2020, there is a direction which has been passed which will actually decipher whether your deeds are forged or fake. All that issue can be agitated before the appellate authority.
That's I am not on that. The only thing is that
Why should I entertain?
no,
entertain
that has been already entertained by this honorable court in earlier two, three matters.
That is a
That
different
has.
Sir, that is a
If it is not, if it was not, it was entertained on the basis of that, and they have acted upon. Well, they have acted on, the BLLRO has acted upon, on the basis of this complaint and the forged document on the basis
go
of
in
that.
appeal. You show all that document in appeal. If they have acted upon and those deeds are found to be forged and fabricated, you go and show it in appeal.
Well, not in these matters. With the other matters where are already, my lord, the honorable court has.
Mr. Gupta, either you come here,
My
because
lord.
yes,
My
get
lord.
the document. I'll keep it tomorrow.
Tomorrow, how can I produce without the leave of the court, the supplementary affidavit to?
There
Because
is no
these
need
are
of
not on.
Mr. Gupta, I'm not giving you any leave of supplementary affidavit. Whatever document you have, whatever order you have, you show it to this court. If I'm inclined,
My
then
lord,
I will give you.
my lord.
I'm not inclined to give you any
lord,
opportunity for
only in
any
that.
supplementary affidavit.
My lord, I need not be. My lord, only
I
in
am very clear, Mr. Gupta, that you need to go in appeal, and I'll dismiss it because you have an alternate remedy available in law. I'm
Well,
not going to entertain your writ petition. You show me the document tomorrow. Let me have a look at it.
day after
Making it
tomorrow.
very clear
Kindly
to-
day after tomorrow. Only indulgence. Let it be day after tomorrow. I will be in trouble. Tomorrow is the one matters as weeks. Day after tomorrow. Only I am day after tomorrow.
Please
Much
understand
my
what
lord,
the
my
court is
lord, my
saying,
lord,
Mr. Gupta.
my lord, much obliged, my lord. But I am not Mr. Gupta. My junior is Gupta. I am Shankarnath Mukherjee.
I can't help it. If
My
you
lord,
put
my lord.
that name, that's the only thing I can do.
Yes, no, there is nothing, my lord, is appearing in the chat box.
It
No
is
names are
Neeraj
appearing.
Gupta.
Yes, my lord, junior is advocate on record, my lord, Mr. Neeraj
So you
Gupta.
please log in from your name.
But I don't know. Oh, my lord, I will. My lord, on the day after tomorrow, my lord.
Day
Let
after
it be.
tomorrow.
My lord.
Item number 3.
My lord, 6, I am appearing on behalf of the petitioner. Item number 6, am I audible?
Yes.
Am I audible, my lord?
Yes.
Item number 6, I am appearing on behalf of the petitioner, my lord.
Yes.
My lord, in this case, the private respondent, that is the respondent number 5, is the is a contract got contract work order from the Mal municipality, and his enterprise name is Mittal Trading Company. That is, I have stated in paragraph 2 of the writ petition. For after that, the private respondent subcontracted to the petitioner and his friend to supply goods or material to the Mal municipality on behalf of Mittal Trading Company. That is the concern of the private respondent. My lord, as per direction of the private respondent, petitioner and his friend supplied all the documents, all the goods as required as per the work order, and after that submitted GST or EOA bill to the private respondent concerned. Kindly see, my lord, Annexer P1, page 11. That is the bill submitted by the petitioner, private respondent. After
Yes.
that, my lord, petitioner further states that private respondent also took a financial assistance of rupees 5,50,000 from your petitioner to enhance the business of the private respondent, and that was sent to the private respondent's wife's account. And all the transaction has been annexed in the annexer page 2, annexer P2, page 30. That is the transaction. Total transaction rupees 5,50,000. My lord, petitioner several time and repeated time approached to pay the outstanding dues and also the loan, also the amount which for financial assistance which was taken by the petitioner, but private respondent did not earn, and as such last on petitioner along with the other member and the private respondent sat meeting to decide the matter, but of no avail. Thereafter, finding no other alternative, petitioner made written complaint to the concerned officer in charge Malbazar Police Station and the SDPO Malbazar on 14/12/2024 for taking necessary action against the private respondent. My lord, I have annexed the complaint, annexer P4, page 51.
Yes.
Page 51, that is the complaint before the SDPO, and after that OC Malbazar.
Yes.
But police has not taken as yet any step, and my prayer is that for taking step to the police, appropriate action against the private respondent to recover the money and appropriate action as per the provision of law.
So what is the law, sir, if the police doesn't lodge an FIR? You file a
My
writ
lord, now is BNSS up.
So you file a writ petition?
Yes. Police in action matter, my lord.
All right. Yes, madam. Obviously, everybody knows that. Only he doesn't know it. No. What is the report?
The allegation which we have made, that was not supported, lodged as file, and we have made this initiative and
All right. So, Mr. Biswas,
Yes, my lord.
you should read the law again.
My lord, 406 of the earlier IPC 406 is applicable because there is,
So if the police is not lodging an FIR, what should you do?
my lord, another is that 156 clause 3 of the CRPC, but
Not
High
another.
Court,
That is the
High-
option.
my lord, High Court has also, my lord, police in action matter, High Court has also entertained the writ petition
Yes.
to the
Take down. Take down. Petitioner has filed the present writ petition, comma, being aggrieved by the inaction of the respondent authorities, comma, who have failed to take any action on petitioner's complaint dated 14/12/2024. Full stop. The petitioner submits that his wife, your wife has transferred, right?
no,
That
no, 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 no. I transferred the
Petitioner-
amount
Yes.
5,50,000 to
Yes,
the
transferred.
wife's account of the private respondent.
He has transferred, that he had transferred an amount of rupees 5,50,000 to the private respondent for business purposes, full stop. However, comma, the private respondent failed to repay the said amount, full stop. Consequently, comma, the petitioner lodged a police complaint dated 14/12/2024, full stop. Despite lapse of a considerable period, comma, no action has been taken on the said complaint, full stop. Aggrieved by such inaction, the petitioner has preferred the present writ petition, full stop. A perusal of the writ petition reveals that the primary grievance between the primary grievance pertains to a private pertains to the recovery of the amount advanced by the petitioner to the private respondents.
No, no, my lord, kindly another is GST bill also that work order and subcontract, the petitioner is a subcontractor.
The amount advanced by the petitioner to the private respondent. Full stop. Full stop. The petitioner further contends that he had undertaken some work for which he has not been paid the amount due to him. Full stop. The dispute, comma, as presented, comma, is purely civil in nature and is between the private parties. Full stop. While the petitioner has alleged inaction on the part of the police, comma, there exist alternate remedies in law to address such grievances, full stop. The invocation of the writ jurisdiction under 226 of the Constitution is not warranted in the present circumstances, full stop. In view of the above, this court is not inclined to exercise
My
its
lord, kindly any direction, my lord,
present matter
to the
accordingly.
police for taking.
Writ petition is dismissed.
My lord, kindly taking, my lord, High Court can entertain, my lord, that jurisdiction, my lord,
I
only
know, but I'm
investigation,
not-
my lord, only,
Mr. Biswas, I'm not inclined, all right? Next.
only investigate, my lord, kindly, my lord, only investigate the police to inquire the matter, my lord,
Mr. Biswas, I have passed an order, all right?
my lord.
So we'll have it after. We'll take it up. 1, 2, 4. We'll take it at 12. Yes.
Malad, I have, Malad, at 12 I have a difficulty as because Malad, court number 5 I have near about 5 matters, Malad.
What can I do, sir? What are you asking? I'm not.
Malad, item number 1 and 2, Malad, they had sought a passover for 10 minutes, Malad.
Yes.
And Malad, at 12 o'clock I will be at difficulty, Malad. I'll have to go to the court number 5, Malad.
So,
Kindly.
sir, I should start running my court according to your difficulty, Mr. Choria.
Malad, otherwise, Malad,
Why were you
tomorrow,
not
Malad.
here in the first call? Wait a minute. At least for the first 5 matters, you should not even ask for a passover.
Malad, I did not ask, Malad. They asked, my lord.
That is the first matter, Mr. Choria. Whosoever has asked.
Malad, the respondent asked for the
We will
passover.
see.
Malad, I
If
did
you're
not
not
object
here,
like
we
that,
will
Malad.
again pass it over.
Number 7. If I'm happy to the petitioner matter, but as here, the subject matter is a different process for the post of Ongolwadi Sahaika.
Yes.
Total vacancy is 140. Madam, before that, I candidly submit that the notification is in Bengal. But all the lordships, the relevant pages are in English, lordship. If your lordships kindly permit, I can, my lord, make a translate copy. Lordship, kindly clear out the matter if your lordships kindly find that the notification system.
Where is the notification?
My lord, notification is page 44. It's in Bengali.
That's okay, ma'am. Yes, tell me, what is it?
My lord, may I read Bengali?
Yes, you can read it.
মেঘলিগঞ্জ সংলগ্ন শিশু বিকাশ সেবা প্রকল্পের অধীনে মোট 154টি পদে সহায়িকা নিয়োগের জন্য মেঘলিগঞ্জ পঞ্চায়েত সমিতিভুক্ত গ্রাম পঞ্চায়েত এলাকায় 147টির জন্য মানে I have this গ্রাম পঞ্চায়েত. So my lord, according to my lord, the total vacancy of Meghliganj Panchayat Committee is 147.
Yes,
With that, my lord, within this.
147.
147.
yes.
Now, my lord, others qualifications, he has to be passed fourth standard and her age has to be 18 to 45 years. She has to be a married or a widow lady. These are the these are the criterias. So, my lord, the petitioners fulfilled all the criterias and my lord, they were called for the interview. My lord, after interview, now lordship kindly comes to page 56. This is an order with regard to the this recruitment process where there is a lack of transparency, that recruitment process remains stayed. And subsequently, in these petitions, that the stay was, my lord, vacated. I am praying, my lord, the petitioners pray for completions of the selection process and publications of the merit panel to the Anganwadi helpers under Child Development Project Officer Shita. It will be Meghliganj, lordship. Subsequently, it is corrected. Meghliganj ICDS project Kujira, the selection process is of the year 2009. The result could not be declared in view and of the order of stay passed in WPA in 2029. It is submitted by the Council for the State that the District Selection and Monitoring Committee Kujira does not exist in view of the departure of 2 members. There is no further impediment in completion or completing the recruitment process of Anganwadi helper initiated in the year 2009. Since WPA 820, where the stay was granted, has been dismissed on 21 September 2020 and all interim orders have been vacated. The Principal Secretary's Department of Women and Child Development and Social Welfare, being the respondent number 2, shall constitute the district selection and the monitoring committee Kujbehar afresh and complete the process of appointment of the Anganwadi helper in Kujbehar 1 Integrated Child Development Scheme. In case all the vacancies have been filled up in accordance with the law, the available impaneled candidates shall be considered against the vacancy that may arise in future. This is the order. Thus, after this order, my lord, the recruitment process was completed.
Yes.
My lord, when completed, lordship, it must be after September 2021 because this order has been passed on 23rd September 2020. So, my lord, the recruitment process was completed in between 21 to 22. Petitioners were not selected or empaneled. Now, my lord, page 60, the petitioner made RTI applications in order to know the cut-off marks and the marks they obtained.
So what were you doing from 21 to 25?
My lord,
Sleeping.
they did nothing, lordship. No, 25, lordship. What is the answer to their RTI applications, lordship? Kindly see. In response to your RTI query regarding individual marks and cut-off marks in the examinations for the post of Anganwadi helper by notification such and such, it is to inform you that no date regarding recruitment process mentioned above is available. No data regarding recruitment process mentioned above is available in the office at present. Hence, the data as requested in your RTI application could not be given at present.
Yes.
My lord, the process has been completed in the year 20 to 22.
Yeah.
25, they are saying that there is no data available in their office. Now, lordships, next page, my lord, they made a
Representations
and the same answer. My humble submissions before your lordships that the petitioners are at least entitled to get the.
Where is the answer to the representation? Same.
Data is available.
On.
Lordship kindly comes to page.
See, madam, a process which started in 2009 culminated in 2021.
2021, 2022.
You file an RTI in 2025.
That
So
is
what
true, Lord.
what were you doing for?
Considered if the processes has been completed, my lord, in the year 2022, within 2 years, they are saying they do not have any data in their office.
Not 2 years, madam, 4 years.
Lord,
Anyway.
kindly see, the petitioners are at least entitled to know their marks and the cut-off marks, and the petitioners, my lord, since they are the resident of the said locality, they know that there are the, my lord, more.
If you were so
practices.
serious about it, madam, you should have filed an RTI much before. What were you doing for so long?
My lord, they
They are not educated? They are not educated?
They are educated up to 4th standard, Lord.
Whatever, madam, they are seeking a job.
They kindly consider.
Anyway, yes. Anything else?
Lordship, thereafter, Lordship, the same recruitment process already challenged and obtained for stay, Lordship. In the year 2022, Lordship. Kindly see the order, Lordship.
What is this? They
Same-
have already
same-
completed the process.
Yes, Lordship, the pending before this honorable court, Lordship, the other petitioner has challenged the said recruitment process, Lordship.
My lord, as per.
So for my instruction, Lordship,
My lord, they have already completed the recruitment process and.
it is pending, Lordship, before the honorable court, Lordship.
Post submit.
Several writ petition is filed, Lordship. Initial law.
You see this, madam? What they are saying?
Kalpana sir, madam. The order দিয়েছিল না।
May I get a copy from my learned friend?
The order is 269 of 2020.
You seek instruction, take this, seek instruction.
Touch.
If that is the case, there's not maintainable.
Yes.
May I get a copy? Lord?
Yes, take a copy, seek instruction from your client. We'll have it tomorrow, day after, when do you want?
Tomorrow,
Yeah.
take instruction. My lord, I'll.
You take instruction.
Yes. And the evidence also.
You take instruction, we'll have it on Friday, ma'am.
We are for the respondent, my lord. My lord, there is alternative remedy, my lord.
My lord, I appear for the petitioner.
Yeah.
Tribunal is there for alternative remedy also.
Yes.
My lord, this is, my lord, we are exercising the order of the appellate authority. My
Yes.
lord, my appeal, the GST Act has been rejected on the ground of delay.
Service tax.
My lord, my only prayer is, my lord, I am covered
Yes.
by a decision of this coordinate bench, my lord.
Yes.
Why, my lord, it has been, my lord, relegated back for condemnation. Now, my lord, for consideration, the application for delay. I would only pray before your lordship, my lord, considering the matter. My lord, the way it has been dealt
Service
with.
tax mean,
My lord, can, my lord,
Service
pass a
tax.
direction to
Service tax.
condone the delay and, my lord, hear the appeal on merits.
You can file an application over there. Why should I condone the delay?
My lord, I will only pray, my lord, this was because, my lord, again, my lord,
You have to come back. Sorry, sir. I can't do that. You know the law very well.
This is the service tax matter, my lord, not the GST.
my lord,
Yes, service tax,
my lord,
cess tax. The
Sir,
tribunal is
Service
there.
tax, yes. Tribunal is
tax.
there.
Cess tax, the tribunal is there. Please
Yes.
go in the tribunal.
The second approach, he has also relied upon, see page 57.
He knows it. He knows it.
57. 57, he is relied also in
Mr.
his.
Agarwal, we are not dealing with somebody who doesn't know the law. He knows the law.
Yes.
Yes.
my lord, I am covered with the decision, probably that is not prepared. My lord, can grant me an opportunity, my lord, to take out an application. Though in my
You will take
appeal,
out an
my lord, we
application.
have stated the grounds for delay, my lord, that was not considered. I will take out a fresh application.
Is there alternate
Yes,
remedy
it is
available?
there.
You go
And he
for
has relied also.
the
in his-
petition in the present writ petition. You want me to, what do you want? You want me to dismiss it?
My lord, I only want the liberty, my lord, so.
Liberty is already there. You move an application for
Yes, I-
condonation.
It has been
They will-
rejected, that's why. It
they
has been
will-
rejected,
The
stating
condonation-
that they don't have the power.
Yes.
But the coordinate bench held that there is a power, you can, the authority can always consider the application for it. So I am only.
where is that rejection?
Yes, my lord, my lord.
First appeal.
My lord, kindly take.
This is the first appeal, my lord. Second appeal is there, tribunal.
You can main, sir, you can take that ground in the second appeal.
Yes, Lordship.
You can take the same ground in the same.
Grant liberty.
No, I will not grant you any liberty. Take down. The petition, the present date petition, you want me to decide it?
But, only one line, my lord.
No, Mr. You go there, we'll see that. The petitioner in the present writ petition is challenging the order dated 7/11/2024 passed by the Commissioner GST and CX appeal, Siliguri appeal commissionerate, full stop. Why the said impugned order, the appellate authority dismissed the appeal filed by the petitioner against the order in original dated 27/9/2023 on the ground that the appeal preferred by the petitioner was beyond limitation. The impugned order is an appealable order under the Sestak Tribunal as per section 86(1) of the Finance Act 1994, full stop. Since the petitioner is having an alternate efficacious remedy available under the statute, this court is not inclined to exercise its discretionary jurisdiction in the present matter. In view thereof, the present writ petition is dismissed.
Let me have it.
Item number 9.
Who's there? Ms. Sarkar, what is this matter?
Ms. Sarkar is not there, Mr. Shah is there. As served his office, sir.
Mr. Shah,
Item number 9.
9.
Very short issue.
Item number, Malad, kindly give me 5 minutes, sir. Who is allocated?
Mr. Moin.
Mominu. He has not yet reached the port, Mr. Rahman.
15 minutes not reached, it's 11 o'clock.
I appreciate.
Passover,
Yes, the matter be taken at 12 o'clock only.
Passover. We'll see.
Item number 10.
Doctor, I think, which sir?
I'm for the statement.
Yes,
My lord, I received the copy yesterday at 6 p.m. I couldn't collect the instruction, my lord.
Monday. When do you want? Monday?
My lord, Monday.
Monday.
1 PM.
He's saying
That
6 PM.
LR, they serve, my lord, they serve at LR, my lord. From LR, it has to be allotted and then it comes to us, my lord.
When do you want? Tomorrow?
No, my lord, Monday.
Tuesday? Friday?
I'm going to Delhi tomorrow for my mother's statement also.
When are you?
My lord, it is not possible to take
He
instruction.
can't seek instruction.
That is very urgent. Counseling is going on today also.
That's all right. Counseling I know is going on.
There is no urgency, my lord, because at
I know there is-
first point, they expressed their unwillingness to join
I've seen
and
that.
now came back and
I've seen that.
Not-
Yes, yes,
Kindly come to page number 21, Lordship.
yes. Yes.
So page number 21, that is the appointment letter also.
Yes.
Which has been received by candidate, that is petitioner, they have looking for on 29, Lordship. On 29, what?
Yes.
After receiving this letter, Lordship, the petitioner could not join because the, if you Lordship kindly, for a moment kindly, see the annexures P1, Lordship. All these are medical documents, Lordship, but which prevented her. Now the question automatically comes, Lordship, why she did not join and why she sent.
Sir, because the mother was unwell. That is the reason.
Suffering from cancer.
Correct.
tested with lung.
That's all right.
Lung cancer
Yes.
tested, Lord. And she
Yes.
was the only person to take care of us.
She could have sought for extension of time. Why she didn't,
Absolutely.
why didn't she seek extension of time?
Absolutely. But Sopati, this is the time. But the situation was so take back at that time, Lord. She was so busy at that time.
Sir, don't make these kind of
Lordship,
arguments. Please.
one thing, Lordship, also, if your Lordship take a look for a moment to the notification, Lordship, which has been published, by the welcome of the Future Commission, Lordship.
Kindly give me a copy.
17 P, subclause P, Lordship, that means within the statutory period, Lordship, within the statutory period, I have just made another application for withdrawal of my later. Not after the expiry of 90 days. Within 90 days, I have made prayer for withdrawing my earlier later. My appointment letter is valid up to for 90 days. And within 90 days, I have made another prayer for withdrawal. Since I had a consultation with the doctor and say she is now better. So I changed my mind and I filed another representation.
My lord, I don't have the copy of that notification, but
You
I would,
copy?
I would request my lord to ascertain whether it is mentioned that a candidate who has unwillingly not joined the service can. So the facts are different, my lord.
The facts are entirely different. You read the. A recommendation letter shall remain valid for a period of 90 days from the issue. The concerned school authority shall, on the basis of the recommendation of the commission, issue the letter of appointment to the candidate joining not less than 30 days through the registered post with acknowledgement due and receipt upon the concerned school authority, and the candidate shall join within the stipulated period as mentioned in the appointment letter. If the Central Commission gets information from any school or from district inspector or otherwise that a candidate recommended for appointment has not accepted the offer of appointment or joined the post within the stipulated period so and so, the Central Commission may do away with his name from the panel and will be deemed to have been depaneled and recommended the name of the candidate in the waiting list strictly in accordance. This is what has happened with you. You have shown your unwillingness to join. You seek instruction. Come back on, when do you want? Tuesday. Come back on Tuesday. This goes against you. Read the. We'll see that judgment later, sir. Let them come back with the instruction. See if you are ready to consider it or not.
Not my lord, because if my lord.
Sir, first, do not go by this. I'll pass an order where you'll consider them. All right?
I was going
So
by the
first,
document, my
you
lord.
please
My lord.
take instruction.
My lord, I will take.
Lawyer's job is to take instruction and come back to the court. You're officer of the court.
My lord.
All right?
I will
Take
bring it.
instruction and come back. Give it on Tuesday.
Item number 9 was marked over everything.
Pass over matters after 12.
But 11 I'm late.
The next matter will add, I must tell you that the outset will add, the similar prayers will add. The matter is being taken up by Justice Vasu, the principal. That was those matters were assigned to him. But to avoid conflict of decision,
I'm sorry, Mr. Ahmed, what are you saying?
that the similar prayers are made in other expeditions also. That those expeditions were assigned to Justice Vasu. Now hearing at principal bench. That the similar prayer is also here.
Who's for the department? What is he saying?
Yes, my lord. In this matter, then it's two general or decision about that is going to appear.
Mr. Bandyopadhyay, where is he?
Yes, my lord.
Mr. Bandyopadhyay.
Yes. Bandyopadhyay আছে 3 number.
Yes, Mr. Bandyopadhyay is also there in the mix.
Yes, but his connection is not good. He's stuck.
May it be kept on 16th of June, so that I can assist the logic physically, my lord.
I'm sorry, Mr. Bandyopadhyay, what did he say?
Lord, may your lordship kindly take it up on 16th of June, my lord, so that I can assist your lordship.
The other matter is principal bench is on 6th of June.
Mr. Ahmed is saying that similar connected matters are pending with Justice Basu.
Mr. Ahmed is representing the state.
Yeah, I'll tell you.
All right, we'll have it on. When do you want, Mr. 15?
16, my lord.
Have it on 16. Not today.
16th is another matter.
16, Mr. Ahmed.
The 16th is fixed with the physical bench.
I'm sorry?
The other matter is fixed with the principal bench on 16th.
That's all right. We'll see that. This can also go there only.
I do not 12. I do not 12.
Lordship, Lordship, item 12, I am appearing for the petitioner. Lordship, am I audible to you, Lordship?
Yes. Partially visible, fully audible. Yes.
Lordship. Lordship, the
Now
the
fully visible, fully audible. Yes, tell me.
I'm grateful, Lordship. Lordship, the matter is relates to a trust. That
Yes.
the trust is run by two persons. One of the representing petitioner, representing representative of the representative of the petitioner is an 87 years old citizen and a bachelor person. For the public interest, Lordship, he initiated one medical college for the medical college to function in the locality for the poor people. And accordingly, due to intervention of the local criminals, subsequently he wrote to the superintendent of police and thereafter come before this honorable court and get an order by Justice Honorable Justice Shampa Sarkar, and on the basis of order, SP Kojbiar has been pleased to pass an order to deposit rupees 3,07,000. Accordingly, petitioner deposited that 3,07,000, but for three constable, one ASI post for 60 days in the respective place. But subsequently, since they could not place deployed the police personnel, relates to that, the earlier writ petition was moved and Honorable Justice Subhosati Bhattacharya has been pleased to pass an order. That is the last order.
Mr. Dhar, when you make submission, please take this quote to the relevant documents.
Lordship, I'm coming to that. I just said. Now, Lordship, kindly come to Annexure P2, page 24 to 28. Page 24, site map of the locality. That is the medical college, and then thereafter, this is the entrance of the page 25 is the entrance of the medical college gate, and thereafter the letter to the superintendent of police, page 26, 27, 26, 27, and 28. And thereafter, the order of Honorable Justice Shampa Sarkar, that is Annexure P3, page 29 and 30. In this order, His Lordship has been pleased to direct the Superintendent of Police to take appropriate steps, giving elaborately of the facts of the case. Now, thereafter, Lordship, the page 32 is the deposit slip. Page 32, 3,07,260. This is the deposit slip. Since thereafter additional police posts could not deploy to the place, therefore petitioner earlier moved a writ petition being WPA 46 of 2021. On the basis of said writ petition, Lordship, this is the last order passed by Honorable Justice Subhosati Bhattacharya, Annexure P4, page 36, 37. In the last paragraph, page 37, Lordship, kindly see that in the meantime, the respondent number 1 shall ensure that 1 ASI and 3 constable of police are deployed at the location for a period of 60 days from date, as per direction of the superintendent of police dated February 26, 2020. And in that writ petition, they told the honorable court that they have deployed 1 police personnel but in spite of that, this direction was passed, since no records is produced. Now, subsequently, the COVID-19 affected and petitioner, the representative of the petitioner society, Lordship, being an aged person, he could not attend the court nor gave any instruction. And ultimately, the matter is disposed of by Honorable Justice Tirthankar Ghosh. Though in the earlier matter, they have been directed to file an affidavit in opposition by Justice Subhosati Bhattacharya. In spite of that, no affidavit in opposition is filed, and matter is appeared before the Honorable Justice Tirthankar Ghosh, and His Lordship has been pleased to dispose of the writ petition on the day by directing since the state has been claimed that they have deployed the police personnel, though nothing is inflected in the order sheet, but because of that reason, the state is directed to serve the copy of report to the petitioner or his learned advocate. Up till now, no report is served. No report is served upon us, but we are being aggrieved with the said report, Lordship. We have come before this court in the earlier writ petition And since there is some technical difficulties, so for first annexure P1, we have withdrawn the said writ petition, page 21, 22, and with liberty we have filed this. So up till now, no report is placed, but in the meantime, no report is communicated us. But in the meantime, Lordship, the local miscreants are creating trouble to the medical college. Entire work is stopped, and some of the local criminals entered into the medical college premises. By entering in the room, they are doing some nuisancing in the premises. Since the petitioner, representative of the petitioner society is an 87 years old, he cannot restrain them. It is not possible for her, so he make prayer before your lordship. Let the district magistrate maybe close the building under by putting it under lock and key, and in the meantime let them serve the copy of report, and on after filing affidavit, lordship, let the matter may be decided whether they have deployed the, because for deployment of police personals, lordship, there must be some documents by way of GD&T and all other things. Nothing has been produced.
I have taken report from my office, no copy has been served upon the statement in this matter.
Serve
We
upon
have
the
sent it
state.
hard. We have soft copy. We have said we have served, but
And this copy they have not served.
Serve upon the state.
this
sir.
copy also served.
Monday. Serve upon the state. Monday, Mr. Counsel, on Monday, please seek instruction. The entire issue is he has paid an amount of 3 lakhs odd, for which he was granted the police protection.
My lord.
He is keep on harping the fact that he has not been given, though the report, the earlier order reflects that he has been given the police force.
My
But
lord.
please verify the fact, come back with a report.
But in course of today, they should serve the copy, otherwise.
I'm telling you what the issue is. Don't you understand what the issue is? The issue is very simple. They are asking for police protection. There was an order which was passed wherein they had given a cost of rupees 3 lakhs for deployment of the police force,
My lord.
whether that had been done or not,
My lord.
and if done, to what period. All right?
Very nice.
What is the status today?
My lord.
Monday.
Monday.
Lordship, may
You
I
have a
serve
copy
again?
on them, Mr. Dhar.
Lordship, already it is fact that
Sir,
I have
again,
sent
they don't
the
have a
copy to Mr. Shubisha through WhatsApp, Lordship.
What, sir?
The entire copy is with to my learned friend and also the DM.
This is the problem. WhatsApp. Serve a physical copy in the office.
Physical copy by tomorrow, Lordship. By tomorrow, I will serve.
Very.
Yes.
I don't know what for a short pass, my lord. I don't know, 14.
Yes.
My lord, I'm sorry to say, my lord, only a notice has been served upon the office of the bank, my lord.
Notice?
Notice has been served. No copy of the petition.
Give a copy.
এই যে খালি নোটিশ গেছে
You're appearing
Yes,
Mr.
authorized
Paul
officer.
for?
For the bank, my lord.
Bank is the necessary party. My lord, whatever has happened.
Only notice has arrived.
Give a copy.
Yes, yes, definitely. Okay, when?
Monday, Tuesday, when do you want?
Tuesday.
Tuesday.
I'll serve it in the course of the day. I'm sorry, my lord, this must have been a mistake.
Tuesday.
I don't know, 15.
All the answering respondents have received mallards except for mallards respondent number 5, who is my husband mallards, and we live under the same roof.
This is with regard to renewal of visa, my lord. Extension of visa.
Mallards, extension of
The
visa and mallards consideration of the
union-
application under section 5. of
The
the
union is the
Citizenship Act.
answering authority, my lord.
Union of India.
Union.
Who's appearing for Union of India?
Mr. Mujumdar.
He's appearing
appeared.
for-
Mr. Majumdar.
My lords, the petitioner, my lords, is a Bangladeshi national, my lords,
Yes.
of Hindu faith.
Yes.
And my lords, she is married to, my lords, respondent number 5, my lords, who is my husband, my lords, in this matter. Now, my lords, we were married in the year 2015, according to Hindu rites and rituals, my lords. I have also, my lords, annexed the marriage certificate, my lords, in page 12. And my lords, since then, my lords, I have been residing with him, my lords, continuously in India, my lords, in Siliguri itself. And my visa has also been extended from time to time. And my lords, the visa is expiring on the 3rd of July 2025. Now, my lords, what has happened is, my lords, after fulfilling all the criteria, I have applied for Indian citizenship, my lords, under Section 5 of the Citizenship Act, my lords. In, my lords, on 17th of July
Have you served your husband?
My lords, husband.
Where's
my
your
lords,
husband?
Husband could not be served, my lords. We
You have to
under the
serve your
same-
husband.
My lords, if
His
would
willingness
grant-
for.
my lords,
am I audible?
Yes, Mr. Majumdar, he has not served the
My
husband,
lord.
he has to serve the husband.
Yes, my lord.
What do you mean you have not been able to serve the husband?
If I may be granted leave to serve by hand, my lords. We live under the same roof.
Why you are not able to serve him?
My lords, the endorsement was insufficient address, my lords, although I had given the address that I reside in. my lords.
Yes, Mr. Majumdar.
My lord, one thing that I could find out from the application is two things that Mr. Bhandari should look also. My lord, he has referred to one Citizenship Act of 1995, but I could not come across any act. Sir. And my lord, there is a 7-year bar. Whatever documents the lady has annexed with the petition does not give us any indication that she was in India or she got herself registered as a foreigner before 2023.
Mhm.
So that 7 years has to be complied, my lord. Whatever papers she has annexed, except
We
the
will have
marriage
it.
certificate.
You serve your husband, we'll have it on Monday. You'll be back, Mr. Majumdar, by
Yes,
tomorrow.
ma'am. Yes. Yes.
Monday.
Number 16.
Grateful.
And in item number 16, my lord, I'm appealing for the respondent number 7, my lord. I'm appealing for the respondent number 7.
Of service, my lord.
Yes.
One of the petitioner is aggrieved by non-payment of his pension, my lord. He was an assistant teacher appointed in the year 2011. He retired on attaining superannuation.
अरे नाम तो दे.
30th of September 2023.
Yes.
Now, before his retirement, within 6 months from the date of his retirement, my lord, he had submitted all the documents in the e-portal. And then, my lord, he retired. After that, nothing happened. If you I'll draw your lordship's kind attention to one letter, which is at page 30.
Read
My
it.
lord, is there? There, yes. This has been sent from the Sub-Inspector of Schools, Matabanga, 1 Circle, Kuchbihar, to the District Inspector of School, Primary Education. Here, my lord, it says, I beg to submit herewith that the pension papers along with original service book and other relevant documents of Sri Jagadish Chandra Roy for taking necessary action with detailed reports. So admittedly, my lord, nothing has happened since September 2024 till May 2025. Now, 23, my lord, and I am without service, my lord. I retired in 23 September 2023.
Who appears for the state? Yes.
They have recently submitted the documents and it was forwarded only on 7th May. 7th May was already process has been taken up for by the concerned DI primary for sanction of the pension. And they have given the representation immediately on 13th May.
13th May, right?
13th May.
No, this is a representation, my lord, which
They have given.
The
The
pension
papers
paper-
has been received by the DI, the
pension
authority
papers,
only
my
on
lord,
7th May.
The papers related to my pension, my lord, were filed in the e-portal before I retired as per procedure, my
They
lord.
were to submit further documents which they have
And no-
recently submitted.
And no communication from the department asking for any further documents or for clarification.
Where is this file right now? With the
With the DI, he has taken up the process and forward to the concerned department.
file your report.
Lordship.
The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent in failing to release his pension and other retiral benefits, comma, even after lapse of 18 months from the date of retirement, from the date of his retirement. Full stop. The petitioner, learned counsel for the petitioner submits that he was appointed as assistant teacher at 101 Fulkabari, comma, 5th Plan Primary School, comma, Fulkabari, District Cooch Behar on 3/6/2021.
Thereafter, I was transferred, my lord, at page 21 to Shadgram, Manabadi, K. Prasad, 4th Plan Primary School. I retired from this school.
Learned counsel, he further submits that he was transferred to
At page 21, my lord.
Page-
Shadgram, Manabadi, capital K, Prasad, 4th Plan Primary Basic School.
He was transferred to Sadgram Manabari K. Prasad, 4th Plan,
Primary
Matabanga 1. Primary School. Full stop. Pursuant to the notification dated 13/8/2012 issued by the Government of West Bengal, it was informed that the National Council for Teachers Education has prescribed minimum educational qualification for teachers. Full stop. According to the said notification, comma, with effect from 2006, a teacher must possess at least this. We'll just simply say.
Because that was part of the earlier writ petition, my lord, that is just since the background, my lord, has to be presented before the court, I had mentioned.
The learned counsel petitioner further states that he has retired from the services on 30th/9/2023. And since then, he had made various communications regarding his disbursement of retiral benefits. Full stop. He states that he has not heard anything from the concerned department. Full stop. The learned counsel for the state respondent seeks and is granted 2 weeks' time to file his report by way of an affidavit indicating steps taken by the department for release of petitioners, pension and other retiral benefits. Full stop. Let this matter be listed after 2 weeks before the next available circuit bench.
Grateful.
Lordship, I represent statements, my lord.
Yes.
Answer the petitioner in item number 7.
I'll just come back in 5 minutes. Yes.
I'm for the petitioner in item number 17. This is my affidavit of service.
Yes.
My lord, this petitioner is a headmistress of a state-aided school lordship, state-aided junior Hindi high school.
My lord, in this matter, my lord, I am appearing on behalf of the Central School Service Commission. My lord, I have instruction to appear, my lord, but I have not received the brief, my lord, from the commission, my lord. So, my lord, I am only praying for not today, my lord, accommodation for the day, my lord.
Already, my lord, I have served, my lord. Service has been completed, lordship.
He doesn't have a copy of the brief.
If he provides his email ID, I can send it to him.
Provide your email ID. He'll send you the brief. He'll have it tomorrow.
Any day, lordship, as per your convenience.
Tomorrow. What is he asking? What are you asking for?
Oh, representation to reconsider. It's pending in the end of the DI lordship. For medical ground, she is praying for her transfer.
No, what is the difficulty? This is just a representation.
My lord, difficulty is, my lord, there is prescribed pro forma for making application for transfer as per rule.
That's all right. He's only asking for.
My lord, whether, my lord, As per rules, my lord, petitioner has to make an application before the school authority.
That has been
And
done.
school authority has to take the opinion of the BOMH, Block Medical Health Officer. And if satisfied, my lord, from the medical report obtained from the BOMH, then my lord, school authority forward it to the district inspector of school. And upon receipt of this transfer application, if the district inspector of school, my lord, again has to my lord, make an arrangement for CMOH verification, Chief Medical Officer of Health.
So you can do all, who's stopping you, Mr.
Kindly come to
Roy?
page number 19. It has been forwarded to the district inspector of school, lordship.
Who's
My lord,
stopping?
then, my lord, your lordship kindly direct the district inspector of school to obtain a report from CMOH, and if my lord satisfied, then kindly forward it to the Central School Service Commission for consideration.
Lordship, I have one point to say in this matter. Lordship, prior to entering into the merits of the case, there is willful suppression of material facts in this matter, Lordship. The writ petitioner had previously filed one writ which has not been disclosed in this entire writ petition. And this writ petition is a replica of the previous writ application. There was a specific direction upon by the court to comply with the order. They have not complied with that order. This is the willful suppression. There is no whisper regarding the previous writ application in this writ matter also. And it is a replica of the previous writ application.
May I submit my lord in this regard to also?
The learned counsels of the petitioner were the same in the previous writ application, and this also it is the same.
Yes, how have you filed? Why didn't you disclose?
I'm studying it, lordship.
Yes.
Same cause of action,
Let me.
same letter, same
I'm
representation.
lordship. At that time, when the previous writ petition was filed, lordship, this annexure, that is annexure P5, which is annexed at page number 90.
I have a very simple question. Where have you stated that you have filed a
With the leave of the court, lordship, I was given a leave by that honorable
Where
court.
have you mentioned this, sir?
That has not been mentioned, my lord.
How can you file a petition without
As
mentioning?
there was a leave, lordship, that's why I filed this.
I'll dismiss it.
Grateful.
Kindly allow me to file with the leave, lordship.
I'll dismiss it and I'll pass observations against you. This is absolute suppression of material
But
fact.
lordship, there was a leave, lordship.
Leave is there, but that doesn't mean that you will not put the record straight before the court.
That was my typographical mistake.
That's not typographical mistake. That's an intentional mistake. You have intentionally not disclosed this fact to the court.
But with the leave, lordship, I filed this, lordship.
Yes. Where is the leave?
Lordship, at the last portion of that order, there was a leave that the petitioner.
Lordship, in the order dated 1/4/2025. Last paragraph, page number.
There was
two,
a leave,
last
lordship.
last paragraph. Last paragraph.
That's a prayer to transfer through the school where she's at present work.
At the last paragraph, lordship, WPA 215 of 2025 is disposed of by giving liberty to the petitioner to make prayer to the transfer application. At that time, when that petition was filed, lordship, that was this document, particularly this document that is at present annexure P5 is there, lordship, that was not given to me. That's why, lordship, that was not annexed at that time. So so that honorable court granted me liberty.
The petitioner has preferred the present writ petition being agreed by the inaction of the respondent authority in not responding to her application, which is the application, same date, 9/4,
Yes, lordship.
to her application dated 9/4,
19/9/2024.
19/9/2024. 19/9/2024 for transfer on medical grounds. It is the case of the petitioner that she is working as headmistress at Khorabari JR Hindi School situated Khoribari, situated at Khoribari district, Darjeeling,
Mother, this is the copy of that order.
from 18/7/2019. She states that her house is 46 kilometers away from the school and she needs to travel almost 96 kilometers daily to perform her duties as headmistress. She has been diagnosed with B/L/OA knee lumbar spondylitis entrapment neuropathy, and hence she has been medically advised to avoid stringent travels. Full stop. Hence, the petitioner had applied for transfer by offline application dated 7/6/2024 to respond number 7, and offline application dated 15/6/2024 to respond number 5. Full stop. However, learned counsel for the petitioner, however, states that till date, the respondent has not considered her application. Full stop. Learned counsel for the respondent state at this stage has handed over a copy of order passed in WPA number 215 of 2025 dated 1/4/2025, wherein the petitioner had sought similar relief and the same was disposed of. And the same was dismissed with liberty to the petitioner.
No, that was disposed of. That
Was
not
disposed
dismissed.
of by giving liberty to the petitioner to make a prayer for transfer through the school where she is at present working.
At that time, that was not with.
Learned counsel for the said fact has not been mentioned in the present writ petition. The present writ petition suffers from material facts and suppression. Full stop. Learned counsel for the petitioner has suppressed these facts in the present writ petition. There is no averment to the earlier round of litigation or the fact that the petitioner had preferred a similar writ petition number writ petition WPA number 215 of 2025 seeking similar reliefs, and the earlier round of litigation also was sought on the ground that the petitioner's representation dated 19/9/2024 shall be considered by the respondent. Even in the present writ petition, the petitioner is seeking same relief. The present
Not
writ
same with
petition,
lordship. At present, it is pending before the DI's and lordship.
the petitioner, since the petitioner has failed to, since the petitioner had suppressed material facts before this court is not inclined to entertain the present writ petition. It is made clear that the counsel for the petitioner has intentionally not disclosed the filing of the earlier writ petition. Such act on the part of the counsel also reflects poorly on his professional ethics. Though this court refrains from commenting further on the conduct of the counsel, the present writ petition is dismissed.
Look, there was
Deeply obliged.
lordship. That's why I filed this. writ
Liberty is to approach the school, sir.
petition.
Grateful, my lord.
Lordship,
Lordship, item number 18, I am for the state. Kindly fix the matter on Monday, Lordship. I will come back with the instruction, Lordship.
Monday.
Grateful.
Lordship, Chairman.
But DI, Lordship, because in the prayer portion also they are mentioned respondent number 6, who is DI, Lordship. So I need some instruction from the DI.
Monday.
Okay.
And as officer of the court, don't do that again.
Lordship, as there was a liberty, that's why I.
But still, you have to mention facts.
Lordship, for
How
this,
can you
I
suppress
tender my unconditional apology, Lordship. But to be honest, Lordship, as there was a liberty, that's why, Lordship, I.
Read the order again. What is the liberty? Read it.
My lord, I am reading the last operative portion. WPA 215 of 2025 is disposed of by giving liberty to the petitioner to make prayer for transfer to school where she is at present serving. At that time, Lordship, when
So
I
the liberty is?
to file representation. Before
Is
the
the
school
liberty
authority.
there to file a writ petition again?
But Lordship, previously.
That's what I'm saying.
To file
You
a
are-
representation.
To representation, not to
Lordship.
file a writ petition.
Lordship.
So disclose the facts.
Lordship. That I mistakenly did, Lordship. But the thing is,
The
that,
you are assuming that the liberty is given to you to file a writ petition.
Lordship.
The liberty is given to you to make a representation to the school authority.
Lordship.
That the application will route through the school authorities.
Lordship.
That liberty is not for filing a writ petition.
What I misunderstood, Lordship, as there was a pending representation and that was not handed to me at the time of filing.
You're a young lawyer. That's why I've refrained from adding more to
Lordship,
it.
I understood.
Otherwise, I'll refer you to the bar council. I'm not doing it.
Lordship, I understood, Lordship.
Grateful, Lordship.
Next.
I don't know, 19. 19, I'm for the petitioners only. No, this is the second round of writ petition, madam. The people also kindly comes to page 50.
Page 15.
50.
50.
50. The first order passed in the other writ petition.
Yes.
Pursuant to this, madam, although the representation was not considered, but payment of DA till 2020 was disbursed, madam. But other reliefs are still pending, madam.
Yes.
An order has been passed pursuant to the said order. This was passed.
This has not been communicated.
Yesterday it was passed.
You hand it over to him, then.
Yes, fine.
Then nothing survives. You have a look at it.
May I look at it?
Yes, absolutely. We'll have it tomorrow.
All the other entitled benefits have been.
Tomorrow we'll have it, Mr.
Tomorrow.
And whatever it is, Mr. Paul, you have to challenge this order.
Well,
Even if you agree,
Yes.
this goes. The present writ petition goes.
Grateful.
Do you want to pass over? Or you want to come tomorrow?
Or tomorrow. I have to take instruction also.
It will be coming to page.
The instruction would be, they might not be agree, I mean, they might not be happy with it, but whatever it is, you have to challenge the order.
Madam.
Order has been passed.
Grateful.
Rightly, wrongly, order is there now.
Acha. Grateful.
Tomorrow, huh? Password. We'll take the password matter.
Password matter. Item number 1 and.
Point. I'm appearing on the CGST department.
My lordship, I am for the petition. My senior counsel will appear virtually.
These are appealable orders. Why have you?
Yes.
Who's your senior counsel?
Literally.
Refund matter. এই কত বলে 155 কত বলে এটা কত কোনটা তো লিস্ট বল
Yes,
your lordship, my submission is that that the initially the refund order was passed.
correct.
Subsequently, during the commissioner of CGST reviewed the order, and it was found that erroneously the order was passed. And
No, but are you arguing on merit or you're taking the ground of maintainability?
yes, practically this writ petition is not maintainable.
That's what I'm asking.
Yes.
Because of section 112, right?
112.
My lordship, the GST tribunal is not yet functional.
That's all right.
That is why we have come before.
When will the GST tribunal be functional?
Already everything has been completed. So far, coming month, appointment has not been coming month or within 45 days or 2 months, it will be resumed.
Mr. Charya?
My lord,
Yes.
my lord, modern exporter of iron steel, my lord. My lord, as per the provision of the GST Act under section 54, I am eligible for refund of the ITC, which I pay in course of my purchases, my lord.
Mr. Charya, the tribunal will be functional within 2 weeks. That's what
No,
the
2
instructions
months.
are. Within 2 months.
2 months.
My lord, it cannot be, my lord. I'm very sure about that. Well, let it be recorded if he is sure, as because recently, my lord, 10 days back, I have met the principal chief commissioner, my lord, not before this year, my lord, not before December, my lord. I'm very sure about this.
You seek instruction.
Yes.
Get back. Monday, Tuesday.
16th, my lord.
16th.
Well, it is a matter of, my lord, it is a settled matter, my lord. Already, my lord, my lord, he appeared in that matter, my lord, settled matter of this honorable court, my lord.
Mr. Charya,
My
if
lord.
it's an appellate provision and if the tribunal is going to be functional, then I'm not interfering. All right, let them come back with the instruction. Come back with the instruction.
Grateful.
No.
Same issue.
Same.
1 and 2, same issue.
1
4
and
is
2
something different. Huh? 4 তো appellate এর জায়গা আছে। কোনটা?
But because in my case, this is covered issue. Because I have seen refund was granted to me.
4 number.
4.
ও 3 আছে।
Password account 3.
4 এটা।
Item 3, who's there?
I make paper for the state lordship.
Item 3, not today. We'll have it tomorrow. Then.
Lordship,
Pass it over.
passed over again, lordship. Because this matter is pending since long and this is a serious issue, lordship.
I know, burial, right?
Yes.
He was here in the morning. Yes. Pastor, to decide his representation, what is the difficulty?
Lordship.
There's a representation he has made.
Lordship, actually, before going to the merit of the case, Lordship, I think private respondent should be the party whose private respondent, actually, the body is the dead body is the daughter of the private respondent. So,
He's not been made a party.
no. I think in front of him, the whole matter should be decided.
Absolutely.
Because there is a mutual settlement of between this party.
You have to make them a party, madam.
Because otherwise there is a religious issue and as
Yes,
well
there's
as
a
the
religious issue. Yes, that's right.
situation is
Right.
not so well in the
Make them a party.
previous days, Lordship. He should be made because his daughter died, Lordship.
The burial of the daughter, right?
Yes.
Learned counsel, the petitioner seeks liberty to make the father of the deceased a party to the present writ petition. Liberty is granted. Service should be effected upon the newly added respondent. List on Monday.
Yes, Lordship. Because I am ready with the matter. Lordship, I am ready with the matter. Lordship, this is their petition and this is pending since April,
See,
Lordship.
you are asking for exhuming the body.
And issue is also serious, Lordship.
Of the body and a proper burial.
That's what I'm
Yes.
saying. So it's there's urgency in the matter. You want, I'll give you next circuit. What's the big thing?
Monday.
Date food. 13টাও ছিল তোদের
Passport matter, item number 4. Meloj, I appeal for the
Hmm,
petition.
job matter.
Led by my senior Mr. Avinash Poddar, he is interested in Bombay High Court. Meloj. The issue is very short, Meloj. Here, Meloj, my refund was sanctioned. Later on, department filed an appeal. Appeal was dismissed only on the ground that the shipping bills have been attested by the inspector and not by superintendent. In my own case, at page number 161, my lords, a similar order has been passed on the same issue. I am seeking for a similar prayer, my lords, similar order. Same issue was involved in page number 161.
Same issue, no?
Certified copy, that is for certified copy. 161.
What difference? এটা তো সেমই হয়ে গেল না তাহলে তো two months time in India, like loaded file.
But later it was certified by the superintendent.
Yes,
In your case, it has been certified.
yes.
By the inspector.
So let them verify, my lords. Let it be.
According to the notification,
Yes.
this had 40, customs notification 40/12. The proper officer is the superintendent who can certify.
So that's what he's saying, that now today the bill has been certified by the superintendent.
Yes.
Earlier it was done by the inspector, subsequently the bills have been certified by the superintendent.
Certified by the superintendent.
That's
But-
what he's saying,
Yes,
that you have to
I annexed
verify.
in the writ petition also. The certified copies are annexed in the writ petition.
But the original is required, original certificate.
Yeah, so we'll produce that.
Yes.
Demand back for this.
Yes,
That is-
yes. Yes, they have not produced the original certified copy.
Subsequently, we have done.
They have not
Where
produced
where
the,
is the original certified copy, Mr. Lapotia?
Meloj, I have annexed it in my writ petition. I will produce them before the authorities.
You have to produce it
yes.
before the authorities
Yes,
on.
Meloj, so we
They have
do
not
that. That is
produced
what I'm
the-
saying.
they
We
have
do
not
that.
produced the authority.
You should have made a representation before the authority with the
Yes.
certified copy.
Because my appeal was rejected, I had no remedy after that. After that, I obtained it.
In this case also, there is a remedy as per section 112. But since the tribunal has not, till date has not yet been initiated.
Right.
Well, within all the matters, we are coming before this court, Meloj. Still,
That's
still
why-
we
So
are-
when will the tribunal be,
No,
Let me take proper instruction.
Yep.
I'll
16th?
on
We'll have it on
16th.
16th.
very well.
Otherwise, we have to entertain these petitions.
And the same facts.
Yes, yes.
My own case.
But in this
I'm
case, it may be remanded back to the authority.
Then my lord,
Because
16.
because he has
Remanded.
not produced the certified copy. If he can be able to produce the certified copy, in that case, order will be also very fair now. After verification,
I'm ready.
it can. No, ঠিক আছে, 16 তারিখে যাবে।
Item number 9. My lord, I appear for the petition.
Yes.
May I please?
Yes.
My lords, I am challenging the adjudication order as well as the appellate order. My appeal was dismissed on the grounds of delay. Not on the grounds of delay, on the grounds that there is no sufficient cause for delay shown in the condemnation of application. My prayer is very simple, my lords. I was denied personal hearing in the adjudication stage. I had made a specific request. What happened in the show cause notice, the date for personal hearing was given on 3rd June. And time to file reply was given on 10th June. So prior to filing of my reply, date for personal hearing was given. On 10th June, when I filed my reply, I filed a specific prayer to allow me an opportunity of hearing. In the order, they denied this hearing, saying that we have already granted one. On the same self-fact, there is an order passed by our coordinate bench that prior notice before filing of reply, this is violation of 75(4), which mandates personal of hearing has to be granted. In similar cases, my lords, where there was violation of personal hearing denial and natural justice violation, and the appeal was dismissed on grounds of limitation, our honorable court has been pleased to set aside both the orders and have sent it back to the authority, my lords. I shall place 2 orders.
First, show me the facts of this
Yes,
case.
I'll kindly come to page number 38, my lords.
Page number 38, yes.
38 is the show cause notice, my lords, 37 and 38. 38, my lords, will find a table at the bottom portion. Details of personal hearing, date on which replies to be submitted 10th June. Date on personal hearing 3rd June. Then, my lords, will come to page number 47, which is part of my reply. My reply starts from page 44.
Slowly. Which page?
44, my lords. My reply starts.
Yes.
My relevant part is 47. (47), the last part, my lords.
Yes.
You are kindly close the proceeding. You are requested not to pass any adverse order before giving an opportunity of personal hearing. Now, my lords, will come to page number 59. Which is part of the adjudication order. My lords, I am taking you directly to the operative part. The first paragraph. The RP in his reply dated 10th June had requested not to pass any adverse order before giving an opportunity of personal hearing. But the RP was already given a personal hearing on 3rd June, as has been clearly mentioned in the summary of the show cause notice dated, did not appear on such hearing and has now prayed for further opportunity. RT has immediately, it is seen RP has repeatedly misstated facts on records and submission without being able to substantiate his claim. Under such circumstances, no further opportunity should be provided to the RP in the interest of remedy. So this was denied to me.
Yes.
And my lords, appeal order, my lords, will see at page number 125 is the operative part, where my appeal was dismissed only on limitation point. Because I could not satisfy the delay cited in the condonation application.
Yes.
Now, my lords, kindly take 75 polls. 75(4), my lord. An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse order is contemplated against such person. So even if I don't make any request, they have to grant me a personal hearing. This has been appreciated by.
So they granted your personal hearing on 3rd of June.
But my lords, what is the purpose of providing a personal hearing before filing my reply? The entire purpose, my lords, is for filing.
You show me, Mr. Lakhotia, anywhere,
Yes,
this
my lord.
section, where it is stated that first you will file your reply and then only a personal
But
hearing
I
can.
highly appreciate on that point, there is a division of the coordinate bench which says that such a opportunity is of no this, and this is violation of 75(4). From our
Violation of 75(4), how can it be violation of
because
75?
I kindly appreciate, lords, the purpose of personal hearing is to satisfy the show cause. Because we file a show cause, then they conduct a hearing, we explain to them why this and this. We even before filing my reply, what purpose will it serve us to give me a personal hearing?
Why you can go.
This
This
point
is
has
your.
been appreciated by our High Court. My lords will kindly take one judgment by passed by Justice Raja Basu Chaudhary, my lord, on this point.
What are the facts of this case?
Same case.
What same case, Mr. Lakhotia? What are the
Case
facts?
number 2, my lords. Para 2, I'm sorry.
Yes, the facts are different, Mr. Lakhotia. Here.
My lords, on the point that the reply, the date to submit the reply was the date.
No,
of
no,
personal
Mr. That was
hearing
just a submission of the
Yes, my lord.
lawyer, but there's no finding to that effect.
My lords, but it was sent back. Kindly.
It was remanded back for the reason that there was no show cause. It is true that the petitioner did not file its response to opposite show cause, nor did the petitioner make an application of personal hearing. There was, however, the same did not absolve. There was no date for hearing given in this fact. No hearing opportunity was granted here. That's the reason it was sent back.
My
It's
lords, in
different.
that case also there is.
No, there is a hearing given to you.
3-6.
There's a hearing given to you.
My lords, and kindly my delay on the grounds of, there are other judgments where on similar grounds where delay was, on the grounds of delay, it was dismissed. This scrutiny bench has passed this order. My learned friends are aware.
Delete our family for a minute.
Then I will be.
There's a receiver.
Just read. What are you reading? Which paragraph?
The present petitioner has challenged the order dated senior so and so on rejecting the appeal on the grounds that the same was filed beyond the maximum period of 4 months from the date of communication of the order appealed against. Mr. Bhattacharya appearing for the petitioner. My lords, I'll come to the operative part, which starts from paragraph, next page, my lords. Mr. Rahman, learned advocate appearing, they were relying on SK Chakrabarti, which has held that Section 5 will apply to GST cases, my lords. Then the state submission is there. Mr. Rahman, learned advocate appearing for the state, submits that the revenue is preferred in SLP, dated diary number so and so against the order of the Honorable Division Bench, and by an order dated 5th August, the Supreme Court has been pleased to pass an order of stay. He therefore submits that the decision of the SK Chakrabarti cannot be said to be a binding precedent. The effect of the order of stay in a binding precedent in a pending appeal before the Supreme Court fell for consideration before a coordinate bench in the case of Piyush Kanti Chaudhary versus State of West Bengal, and others reported in so and so. In paragraph 13 of the said reports, the coordinate bench held that the effect of the order of stay in a pending appeal before the apex court does not amount to any declaration of law, but is only binding upon the parties to the said proceedings. And at the same time, such interim order does not destroy the binding effect of the judgment of the High Court, inasmuch as the precedent, because while granting the interim order, the apex court had no occasion to lay down any proposition of law inconsistent with the one declared with the High Court, which is impugned. In view of the decision of Piyush Kanti Chaudhary, this court is inclined to accept the submission of the advocate appearing for the state that the decision of the SK Chakrabarti cannot be said to be a binding precedent upon this court. Sorry, the petitioner. The Honorable Division Bench in SK Chakrabarti has held that the provisions of Section 5 have not been expressly or impliedly excluded by Section 107 of the Act by virtue of 29(2) of General Clauses Act. The Honorable Division Bench has held, they have quoted SK Chakrabarti, my lords. And then at page number 5, thus it is well settled that in the absence of specific exclusion of Section 5 of the Act of 63, it would be improper to read an implied exclusion thereof. After going through the impugned order, this court finds that the appellate authority rejected the appeal on the grounds that same was filed beyond the period of limitation from the date of communication of the order. The appellate authority did not consider the prayer for coordination of delay on merits. By applying the ratio, the file is sent back to the authorities.
But here they have considered your reasons. They don't
Yes,
find it
yes,
to be
yes.
cogent.
They have considered, they have applied their discretion, and they have rejected mine.
Yes.
Yes, my lord.
So
My lords, but kindly see, I have given them all the documents as well. They have also considered. And one of the major, another point, my lords, I thought I would not take this, but since my lord is not satisfied till now, my lords, all these notices and orders which were uploaded in my portal were uploaded under the tab additional notices and orders, rather than uploading it under view additional notices, view notices and orders. There are two tabs, my lords. The GST portal is a very complex portal. There are two tabs. There are several tabs. Two among them is, one is view orders and notices. Another one is view additional orders and notices. My case is that my notices and orders, everything was uploaded in view additional notices and not in view notices and orders. On this point, my lords, there are decisions by our High Court as well as several other High Courts as well, my lords, that this is not a proper service. So, because I was not aware, my lords, because of their complexity of the portal, I was not aware, my lords.
yes.
If my lord want, I'll place the compilation.
Compilation for what?
For additional notices on the point of this. Now, the first one is the judgment passed by coordinate bench. Here also, my lords, the appeal was dismissed.
Not required. Not required. Yes. Anything else?
This is my case, my lord.
Yes.
Well, this with regard to this additional notices difficulty which they faced, my lord, that has been rectified by the department, my lord, and the additional notices are simultaneously on the same page, and even in and they have not enclosed that document also to show they have not. They have not enclosed that document to show that. And most importantly, my lord, the show cause notice clearly shows that they were given a personal hearing. They chose not to come before the department, my lord.
Yes.
That is one of the point, my lord. And with regard to the adjudication order, my lord, they couldn't show the delay. There was a huge delay of around
3 months.
4
3 months, 22 days. Beyond 4 months.
Beyond 4 months, more than 4 months.
more than 4 months delay it was, my lord.
Yes.
Okay, 4 months 20 days, my lord.
This is after 3 months.
After 3 months.
Statutory.
It was actually 7 months. 7 months 20 days after which they have filed the appeal, preferred the appeal, and there was a delay of 4 months 20 days, my lord.
Beyond the statutory.
7 months.
And yes, my 7 months 20 days.
In total, 7 months, 20 days, including the statutory period of 3 months.
Yes.
My lord. And therefore, they couldn't explain the delay, and therefore the authority have rightly rejected their appeal application on the ground that there was no sufficient ground for condoning the delay.
All right.
Let's take up page number 124.
124.
The documents which have been submitted by the petitioner did not pertain to the period for which the delay was to be excused. Page number 124 clearly explains. The appellate authorities.
Yes. Anything else?
No, my lords, that is my case.
The petitioner has preferred the present writ petition assailing 1, Roman 1. The assessment order dated 12/8/2024 passed by respondent number 2 under section 73 bracket 9 of WBGST Act read with section 20 of the IGST Act, whereby the respondent number 2 being the assessing authority confirmed the demand of rupees 17,79,242 against the petitioner. Roman 2, the appellate order dated 23/4/2025 passed by the respondent number 3, whereby the appellate authority refused to condone the delay in filing the appeal and dismissed the same on the ground of delay. Full stop. Facts leading to the present case are as follows. The return filed by the petitioner under section 39(1) of the 39(1) read with section 4 of the WBGST Act and Services Tax Act 2017 for the period 1/4/2019 to 31/3/2020 were duly verified by the respondent authorities. Full stop. Upon such verification, certain discrepancies were detected. Full stop. Accordingly, an intimation was sent wide letter dated 1/4/2024 to the petitioner, pointing out the said discrepancies. Full stop. The petitioner was called upon to submit a reply, if any, by 12/4/2024. Full stop. However, the petitioner failed to submit any reply within the stipulated period. Subsequently, show cause notice dated 10/5/2024 was issued, directing the petitioner to explain why tax, interest and penalty should not be imposed. Full stop. The petitioner submitted his reply on
10/6/2020.
10/6.
Yes, ma'am.
10/5 is the show cause notice.
Yes, page 44 is my reply.
10/6. The show cause notice, the petitioner submitted his reply on 10/6/2024. Full stop. After considering the reply, the respondent authority proceeded to pass the assessment order dated 12/8/2024, determining a final demand of rupees 17,79,242. Full stop. The order was uploaded on the WBGST portal. Full stop. The petitioner thereafter filed a belated appeal on 2/4/2025, right?
My lord.
Give the date.
Yes.
2/4/2025, which is 7 months and 20 days after the date of the assessment order. Full stop. The appellate authority, while its order dated 23/4/2025, refused to condone the delay and accordingly dismissed the appeal on the ground of limitation. Full stop. Being agreed by the same, the petitioner has preferred the present writ petition. Learned counsel for the petitioner submits. Learned counsel for the petitioner, Mr. Dheeraj Lakhotia, submits that the petitioner became aware of the assessment order dated 12/8/2024 only in the month of March 2025. Full stop. It is submitted that the said order was not available under the commonly accessed tab. What is the tab? Tab title?
View notices and order.
Tab title. Inverted comma mein kar dena, view notices and orders.
Page 61, my lords, I have annexed.
On the WBGST portal, but was instead uploaded under a different tab, namely
Additional notices and orders.
Additional notice.
Inverted comma, view additional notices and orders.
My lord, if your
Full stop.
lordship goes to
As a result, the petitioner was not in possession of or aware of the passing of the final order. Full stop. It is further submitted that no personal intimation, whether by SMS or email, was sent to the petitioner regarding the said order. Full stop. Learned counsel further submits that during the relevant period, one of the partners of the petitioner, mother of the partner, right?
As well as partner. my lords.
One of the partner of the petitioner firm underwent surgery while the mother of the another partner was critically ill and undergoing medical treatment. Full stop. Owing to these medical emergencies, the petitioner was unable to prefer the appeal within the prescribed period. Full stop. Learned counsel further contends that the delay in filing the appeal was neither deliberate nor intentional, but occurred due to bona fide and unavoidable circumstances. Full stop. Accordingly, he prays for condonation of the delay and that the matter shall be remanded back to the appellate authority for consideration on merits. Full stop. Per contra, comma, learned counsel for the respondent,
Ms. Sarkar.
Ms. Sarkar, submits that the petitioner has failed to demonstrate any sufficient cause for condemnation of delay in filing the appeal. It is submitted that the appeal was preferred only on 2/4/2024, i.e. after a delay of 7 months and 20 days from the date of the assessment order dated 12/8/2024. Full stop. Learned counsel, Ms. Sarkar, further
20.
submit
It's 2025.
2025.
22/4, sorry.
2/4/2025.
2/4/2025, sorry. 2/4/2025. Learned counsel, Ms. Sarkar, further submits that the medical document relied upon by the petitioner pertains to the year November 2024 and January 2025, whereas the delay continued even thereafter and the appeal was filed much beyond the statutory period. Full stop. It is therefore contended that no justiciable ground has been made by the petitioner for condoning such delay, and in the absence of sufficient cause, no relief or condemnation can be granted under section 107 of the WBGST Act 2017. Full stop. Anything else?
My lord, with regard to the additional notices, my lord,
Yes.
in page number 61, my lord, if your
Yes.
lordship comes to page number 61.
Yes.
My lord,
Yes.
both the columns of notices and order and additional notice are
On the same page.
same page, my lord. It is not so, it is, they couldn't see it, my lord. And moreover,
Side by side.
the notes, my lord.
Ms. Sarkar further points out that the additional notices were also issued on the same,
This portal, in the
were also available on
the
the,
same page of the portal.
were also available on the same page of the portal.
Portal, and the notes to it clarifies that under additional notices and order, what notices will be available. My lord, kindly go to page number 62, my lord. My lord will find, my lord. Following notices or order issued by tax authorities are available under additional notices and order. Notices order pertaining to module, advance, ruling, appeal, assessment, adjudication, audit. It clarifies that what notices will be available. That notes clarifies, my lord. They
She
can
further states that the note appended at the portal further clarifies the notices which have been appended on the portal,
which will be uploaded in the additional notice
View
and
additional notices
which appended in the portal, which
under the view additional notices tab.
under the view additional
Notices and orders
notices
tab.
and orders. Yes. Yes.
My lord, this is the photograph of the tab where the notices, all the tabs are there. So it's a highly complex portal, my lords. And what she's submitting is that inside the additional notices tab.
These are just submissions. Anything else?
my lord, and একটা point বলেছিল? And
All
with
right.
regard to the show cause personal hearing, my lord.
Personal hearing we have taken care.
Right.
Ms. Sarkar further points out that the show cause notice itself shows that the petitioner was granted personal hearing as well as an opportunity to file his reply to the same. Full stop. This court has heard the arguments advanced by the party and has examined the materials on record. The issue regarding the power of the appellate authority to condone the delay in filing appeal under section 1074 of the WBGST Act is no longer res integra. Full stop. The division bench of this honorable court in SK Chakravarti and Sons versus Union of India, reported as 2024-123 GSTR 229, has already upheld the power of the appellate authority to condone the such delay subject to statutory limitations. Thus, the only question remains for consideration is whether the petitioner had shown sufficient grounds for the delay in preferring the appeal, full stop. The appellate authority has specifically addressed this issue in the impugn order and recorded page, what were you showing, Mr. M?
Page number 120.
Recorded the following findings on page 124. Full stop. 124 में ना copy कर लेना. 124 to 125. As the appellate authority has correctly observed, comma, the medical prescriptions tendered by the petitioner relate only to the period November 2024 and January 2025, comma, whereas the assessment order has already been passed on 12/8/2024 and was uploaded on the GST portal on the same day, full stop. Under the WBGST regime, comma, every registered person is deemed to have notice of orders made available on the designated electronic portal under Rule 142 1A, read with Section 169, full stop. The petitioner, being a registered taxable person, comma, cannot plead ignorance of any order merely because it was placed under a different subfolder, full stop. The Supreme Court has repeatedly held that when the statute prescribes an electronic mode of service, comma, the onus lies on the assessee to remain vigilant, full stop. Tax statutes, comma, especially those governing indirect taxes, in indirect tax administration, comma, mandate rigid adherence to timeline in order to maintain certainty and finality in revenue collection. Section 107, 1 and 4 of the WBGST Act reads, वो दिखाना 107 और 104 इसमें निकालो. उसको कॉपी कर लो 107 में. ठीक है. The appeal in the present case was preferred 3 months and 20 days, right? Beyond the beyond the days beyond the outer condonable limit, comma, bringing the total delay to 7 months 20 days, full stop. The prescriptions, the medical prescriptions cover only a part of the delay window and do not explain why the appeal could not be drafted and presented during the substantial period from February 2025 to April 2025, full stop. The petitioner is a partnership firm, full stop. Even if one of the partner was indisposed, comma, nothing prevented the other partner or authorized signatory from acting, full stop. Section 169D 1D provides that any of the mode listed therein is sufficient service, full stop. Uploading on the portal fulfills the statutory mandate, comma, supplementary intimation by SMS or email is facilitative, comma, not obligatory, full stop. In the absence of any cogent or comprehensive explanation that covers the full period of default, the petitioner has failed to demonstrate sufficient cause within the meaning of section 107(4), full stop. Consequently, comma, the refusal to condone the delay is perfectly in consonance with the statutory framework and the settled principles of fiscal discipline, full stop. For all the foregoing reasons, no perversity or jurisdictional error is discernible in the impugned order, comma, it warrants no interference under section 226 of the Constitution. The present writ petition is dismissed.
I'm
Grateful.
Grateful. Nambini. Make a book.
ये वो हाँ, अरे, इसके बिना ये और चाहिए है ही नहीं. Yes.
I don't know what cutting.
I beg to appeal for this.
13.
Few minutes ago, he's here with you.
Yes, that's right. Where did he go? Just here.
He's come, Lordship.
Yes.
One of the petitioner was an off was stolen. Allegation was made the petitioner from off.
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 You stole the ox.
So I have not. The allegation was that the petitioner son was called by a person was subsequently he found the mob was waiting. And the mob, by the mob, he was brutally assaulted and he was hospitalized. Petitioner went to diarize the petitioner, the father of the victim, but went to diarize the matter. No FIR has been lodged. Although after the victim, as he was hospitalized, he was taken to custody and subsequently he was granted bail by the law. But the police personnel, as well as the culprit, who brutally beaten him, brutal petitioner son, no FIR has been lodged. Subsequently, I have made a complaint over that case. I think nothing has been made. As soon as I have filed the big petition, they have filed a case, bailable offence, all the sectional bailable, 117(2), 126(2), 3(5), and 74 of the PNS, corresponding to 325, 339, 354, 34 of the Indian Penal Code. I was hospitalized, my son was hospitalized, he was hospitalized for 3 days. Subsequently, he was transferred to jail. So the section is mirrored, and even now none of the accused persons have been arrested.
Yes, why?
Lordship, FIR has been registered, Lordship.
Why
but-
FIR registered under these provisions? And
Lordship, I am coming to the point, Lordship. Actually, this petitioner and his father, they are the habitual offender and they are also involved in the cattle smuggling, Lordship. And several
alright.
FIR was there, Lordship. We have the documents, Lordship, and also I would like to submit that, Lordship.
What is the document?
Lordship, previously in the name of the writ petitioner, 2 cases has been registered. That is under section 447, 427, 34 IPC, along with section 3 of the PDPP Act, Lordship. And another case was Rajganj PS case 147/2021 dated 22/4/2021. And in the same section, Lordship, and both the cases charge sheet has been filed, Lordship. And regarding this case, Lordship, 2 persons previously manhandled by the local villagers, and from there we come to know the name of this name of the son of this writ petitioner, and previously so many allegations of there regarding the cattle peddling, Lordship. And Rajganj is a sensitive area, and in this situation, Lordship, every day there is a cattle smuggling is going on.
No, that's all.
And they are detected by they are caught by the
See, madam,
red-handed by the villagers, Lordship, local villagers, and they
So you have to take action against if he has
yes,
been.
Lordship, they handed over the petitioner to the this son of the petitioner to the BSF, Lordship.
Yes.
Because and from their police station.
No BSF, the local personnel have.
And police
brutally
felt that
assaulted him, And your lordship can.
But every day there is a cattle smuggling is going on, and every day so many cow was theft by this petitioner lordship. This is our report, lordship.
See, madam, as far as that is concerned, they will take action.
Yes, lordship, we already registered the FIR against the mob, lordship.
You have,
Investigation is still going on. Lordship, we have the sufficient time, lordship, to adding the section, lordship. We will get anything during the investigation.
file your report.
Lordship, this is our report. I would like to submit the report, lordship.
File a report with a affidavit, not like.
Lordship, then I will come back with the report in the form of affidavit, lordship. Lordship, kindly.
Injury report, I was hospital also did not provide me the injury report.
Take down. The petitioner has preferred the present writ petition being aggrieved by the police inaction in not taking the complaint of the petitioner dated 12/4/2025
Injury report also there. Lordship, injury report also there in the.
filed by the
Lordship,
petitioner
come back with the.
to the officer in charge, Rajganj Police Station. Full stop. It is the case of the petitioner that on 7/4/2025, the accused persons called upon the petitioner's son. What's the name?
My name is.
Son of the name of the son is lordship Riaz Mohammed.
Riaz Mohammed,
Riaz Mohammed,
who is
seen to alias Riaz.
approximately 18 years old. Riaz Mohammed, who is approximately 18 years old at about 4:30 p.m. and asked him to come to Hudi Bhita forest near Saho River. Upon reaching there, he saw a mob waiting at the said site, full stop. It is contended by the petitioner that his son was brutally beaten up by the mob present at the site, full stop. Even he further states that even police personals were present at the site, but no action has been taken by the police in preventing his son to be beaten up by the mob.
Lordship, actually, police personnel was not present at that time. They rescued the petitioner.
That's his contention.
Lordship.
I have the photograph.
The petitioner had filed a complaint dated 12/4/2025 and alleges that no FIR has been lodged till date. Full stop. Yes, now say. Learned counsel for the respondent state refutes the said allegation. She states that no police personnel was present at the site. Full stop.
They went
She
and raised
further,
the petition.
she further contends that the police reached at the site and saved the son from being
Mob.
beaten by the mob. Full stop. She further states that an FIR has already been lodged. When did you lodge the FIR?
Lordship, we have lost the FIR. Lordship, there's a 24/5/2025.
24?
5/2025.
24/5/2025, full stop, and the said investigation is under progress, full stop. In view of the said statement, nothing survives in the present date petition. The police is acting in accordance with the FIR. The police has acted in accordance with the representation made by the petitioner on 12/4/2025 and has lodged an FIR, and the said investigation is under progress, full stop. Nothing survives in the present.
Lordship, only one more thing I want.
I was hospitalized. I was hospitalized for 3 days.
I have the medical report.
They are conducting their investigation. I am not interfering in their investigation.
Lordship, medical report is with me.
Sir, you have.
Lordship, they have filed this writ petition to save from the, they're continuing their business, Lordship. They're the habitual offence.
All that will come during the course of the investigation. All right. You have filed this petition seeking a direction that no action has been taken. Action has been taken by them. The matter is sub judice. They are investigating it. Whatever the outcome will be, abide by it. Sir,
That report they have relied,
if go before the, there's no report which is filed.
but they have no kind of water they have, I don't know what they have given the report.
They have not given any report. I have not taken any report on record.
Document they are believing, but I don't have any.
Go before the trial court and allege everything which is there. You have come here, sir, you know your rights under the law.
I know,
All, then do it.
No, the Indian side is doing the.
All. You are also intentionally doing many things. Look at your conduct.
Continuing
Nothing
their
surprised. The
business.
present writ petition is disposed of. Nothing disposed of.
Get cooler.
Item number 20.
Similar to item number 9, where they have passed the order yesterday. In
Oh.
this case, order has been passed. But they have concentrated only on the DA portion.
Whatever it is,
They have challenged the order.
you challenge the order.
Yes.
Lordship, I will.
Concentrate on the DA portion, but there are paid fixation.
Lordship, I spoke with the department, Lordship, so we need some time to calculation all this thing, the fixation of DA and all. Lordship, I will come back with the report on Monday, Lordship. I don't
Monday
know
will
how
have it?
much, how long they will taking the time, Lordship, because it will be a big issue.
Then you file a report.
Lordship, by Monday, I will come back with the
Monday,
report.
take instruction, come back on Monday. Otherwise, we'll issue
It
notice.
will take time because we have to calculate all these things, Lordship.
Then in that case,
Because
then-
the order itself says within 4 weeks they have to disperse the order.
Lordship, kindly fix the matter and Monday after that, Lordship will decide.
Monday. All right, Monday.
Great. Oh, interim chairman. Grateful, Lordship.
There's a, madam, there's an order which has already been passed in this, you have the copy of the order.
Last one.
No, but you are aware of that order, then you should have not pressed the other writ petition.
That is the order.
Here you have challenged the order. In the other one,
Receipt today.
you have drawn it, Mr. Paul.
They have supplied the order to us.
Yeah, but you are
That
not.
is the different matter. They are working.
Put a tala
All right, we have kept it.
This is Himul, Lordship. I'm not aware with another day.
21.
Now they have joined the mother dairy over there.
Item number 21.
21 are for the petition order. The petitioner is applying for interest on gratuity model.
Interest on
Joined the service in the year 1977 and retired on 2015. And the gratuity was paid on 23rd October 2024.
So after so long, you thought of interest.
Correct, sir. 24 gratuity has been paid. I'm paying for, retired on 2015.
Yes. Interest you're not paying. The petitioner has preferred the present writ petition.
It puts kindly. Where 7% interest has been awarded, if not paid within that time, then 9% will be.
हाँ बोलो नीचे
We can dispose it off
Yes, my lord.
in view of this. The petitioner was initially appointed as
Appointed as a he was appointed as supervisor. Page number 4, first paragraph.
the petitioner was initially appointed as a supervisor in, this is Himalayan Cooperative Milk, huh? In Himalayan Cooperative Milk Producers Union Limited, for short HIMUL. Full stop. He retired from the service as deputy manager on 31/7/2015. After a long drawn litigation, i.e. in WPA number 860 of 2019, MAT 69 of 2022 and CPAN 33 of 2022, his retiral dues were released to him on 23/10/2024. Full stop. He got his retiral dues after 9 years of his retirement. The petitioner has preferred the present writ petition claiming interest on the said retiral dues.
Gratuity and leave interest.
Interest on gratuity and leave encashment. Leave encashment. You were paid interest and gratuity on this 23/10/2024, right? Only the interest has not been paid. You were paid the ethical law. The petitioner states that the gratuity and leave encashment were paid to the petitioner only on 23/10/2024. Since there was a long delay in payment of gratuity and leave encashment, the petitioner has prayed for interest on delayed payment of gratuity and leave encashment. Mr. Paul, learned advocate appearing for the petition, submits that a coordinate bench in writ petition number WPA 737 of 2025 had in coordinate bench writ petition number is pehle ye dal do WPA 2029 of 2024 in the case of Subir Kumar Mukherjee at Subir Mukherjee versus State of West Bengal and others, passed an order on 20 September 23, 2024, directing the concerned Treasury officer to pay interest at the rate of 7% per annum with effect from the due date till the date of actual payment. Full stop. He further submits that in the said order, it was further provided that if the amount of interest as directed to be paid, is not disbursed within period of 8 weeks from the date of communication of the order, an additional interest at the rate of 2% per annum was also directed to be paid. Mr. Pritam.
No, but Kumar Shantanu.
Kumar Shantanu, learned advocate appearing for the state,
Along with Mr.
has made his submissions. This court finds that the coordinate bench after noting that a retired employee has a right to get his retiral dues on the date of attaining superannuation and gratuity and pension cannot be said to be a bounty to be handed out by the state at its whims. To be a bounty to be handed out by the state at its whims. The coordinate bench further held that if such payment is delayed, the retired employee is entitled to get interest on such delayed payment. The coordinate bench accordingly directed the concerned treasury to pay interest to the petitioner at the rate of 7% per annum on the gratuity calculated on and from the due date till the date of actual payment, provided the delay cause was not attributable to the petitioner. The coordinate bench further directed that if the aforesaid amount is not disbursed within a period of 8 weeks, the concerned authority will be bound to pay to the employee additional interest at the rate of 2% per annum on account of delayed payment of gratuity to be calculated on and from the due date till the actual payment. The petitioner retired from the service on 31/7/2015, and the gratuity and leave encashment were released after a long delay only on 23/10/2024. The petitioner has a legal right to get the retiral benefits immediately upon his retirement and is entitled to interest for any delay in disbursing the same by the authority, if such delay is not attributable to the employee. Full stop. After hearing the parties, this court finds that the writ petition stands on the same footing with that of writ petition number WPA 2029 of 2024. In view thereof, the said decision shall squarely apply to the case in hand. Accordingly, WPA, what is this? 1188 of 2025 is disposed of with the following direction. Same, just tick to tick.
Deeply obliged.
The rest of the matters after lunch. There's the same direction.
अगर आप वेबसाइट को मेरे को टाइम दे रहा है 10 और एक बार हम लोग शामिल है नाचे का मास्टर के लिए कुछ फीचर्स और कौन भी नहीं किया यार ये सोच
इसका मतलब है दो बार पाल कर चाहिए
এখানে হলো 21 But I'm already making also what distance 26 system. না আমাকে বলছিল তুই কি খেতে যাবি চা আর কি আর একসাথে কি খাবি তুই যেটা ভাবছি ওটা না বলছে না ওটাই
আমি জানি কি ইনফরমেশন দেবে তুমি তো আনতে আনোনি আমি সেদিকে গিয়ে খেয়েছি
গিয়ে না তোমার বাড়ির পাশে কই
আমি বললাম তো আমি গিয়ে আমার বাড়ি গিয়ে খেয়েছি
আমি কালকে জানিয়ে দিতে পারবো
তার আগে
তোমার বলতে জানি
তোমার তোমার জানি
তারপরে শুক্র আসলো না তোমার ডিস্টার্ব হয়ে গেল না
সেদিন আমি নিজে
তুমিও আসুন না ওই তো বসে আছো
হ্যাঁ
বলেনি নাকি
বলেছে বাবা বলেছে আমাকে বলছি বাবা বলে নাকি আমি সিটিতে খেয়েছি
ওটা ছিল স্ট্রবেরি চিজ
হ্যাঁ বলেছিল না এই চলে গেলে
নাম নিয়ে আর করবো ঠিক আছে কথা দিতে
হ্যাঁ কিন্তু তুমি
প্রবলেম হচ্ছে তুমি তো বড় এবার আমি নিয়ে আর বাইরে বসে দিয়ে
না আপনারা অতটা দেবে আপনি ফোন করে দিও না আমরা এখন আসবো স্কুলটা বন্ধ ছিল
¿Qué pasa? Next week, একদিন আসবে বলে সব সময় কি হবে জিনিস বলতে পারবো তখন একটা ইন্টারেস্ট করতে হবে এত মোটা সব ভালো দেখে মাথা করোনা বারবার বলছে বলেই যাচ্ছে অনেক পার্টি তাও মনে করবো সোমবার রাখো না আমি তো একটাই ওইটা একটাই হবে। কি করবো? কি আছে? কি করবো?
Yes.
Yes, Mr. What is the matter? What did we see? I was here long time. जज बोलने से पहले टोटली दिखाओ बोल देना भाई जब तक जज थोड़ा सा दूसरा नहीं करना तब ये क्या ये आपने ये आपने जज के साथ हो गया ये इस में लौट तो मैं चुला दिया अरे ऐसा
किया आपका सीनियर बोला है हम नहीं बोला उनकी within 3 weeks tribunal will be constituted
last week बोला था 45 days
heavy pehla data hai aap
45 days पहुंचे ना आगे बोले वो तो आराम से वापस देखने के लिए तो बोली सर
वो ट्राइब्यूनल के कारण भी है
हमको बोला था ना बन जाएगा
प्रैक्टिस जो वहां जाना पड़ेगा अरे वहां के अच्छा होगा
कम हो जाएगा
अभी तक नहीं है কিন্তু 4 তারিখ ভুল করলাম तो लिस्ट अच्छी ब्रो हम तुम्हारी एक इधर तेरा चाहिए बोलो अपना बोलो नहीं नहीं आइटम का भाई नहीं कभी इनकम टैक्स ইনকাম ট্যাক্স তোমার যে সিকিম আছে না যে গুয়াহাটি আছে ওটাও কলকাতা ना फिर भी आप सोचो गुवाहाटी का भी है इधर दे देता हम लोग थोड़ा काम कर लेता है
इधर हम लोग ना आफ्टर रीओपनिंग ये जो होने के बाद ना क्या आस्क फॉर दैट एक तो इलेक्ट्रिसिटी का बेंच होना बहुत जरूरी है
हां
और एक यूनिवर्सिटी का बेंच होना
और ये टैक्स ट्राइब्यूनल्स
टैक्स ट्राइब्यूनल और इलेक्ट्रिसिटी आइटम का बहुत जरूरी है
ऑल द ट्राइब्यूनल शुड बी हियर एंड
ए बेंच
यस
कि भाई पहले तो भाई किसी को तो बेंच बना सकता है इलेक्ट्रिसिटी किसी को बना सकता है जब वहां बेंच हो जाएगा
ऑर्डर लिख के लाया था नोट बना के लाया रिक्वेस्ट किया इन लोग तो अभी कर रहा था स्टेट वाला मांगा वो लिख के लाया
Yes.
Second number 22.
Now we are for the state.
Next circuit. Complete the circuit, the service. Why do you want the next circuit?
So I have come to know from my learned friends from the state that the SMC has been made a party, but no copy has been served for us. Then in that question next week.
Learned counsel petitioner
Next
seeks an adjournment. Request for the next circuit.
next.
I for the petition for service is yet to be effected, let it be any days the next week.
Instruction is also required, my lord. State law.
Not today,
Next week.
next week,
Next week.
Thursday, Wednesday, Thursday.
For item number 24, I agree.
Yes.
For the
Number 24.
And the petitioner's registration certificate has been cancelled.
Yes.
In this matter, I have instructions that the petitioner is ready to pay all the penalties, fines and taxes, everything. But it was a COVID period and he's a very small businessman. And he didn't have any proper professional guidance. So when he approached me, I instructed him that I stayed here, that's why I approached the report. But your lordship, I've also annexed the division bench's order along with this coordinate bench's order where I cannot prefer an appeal, but the petitioner's registration was restored. So if your lordship may kindly give directions in accordance with that. Lordship, page number 20 is the.
Show the documents.
Lordship, the show cause notice is page number 18. There is discrepancy in the show cause notice as well. If your lordship may see that.
Show cause notice, page 18. Yes.
Hereby directed to punish or reply to the notice within 7 working days from the date of filing. If you fail to punish or reply within the stipulated date of fail to appear for personal hearing, lordship, no details of personal hearing was given as well. If by chance the petitioner would appear.
So what were you doing since 21?
Lordship, they didn't have any work at hand and they were very strong during the COVID period and they did not get any work as well. Right now, things are. Yes, right now things are looking up and they're getting work contract. That's why they want to pursue their business. So that is why they're approaching this honorable court.
Yes.
The correct provision would be to seek revocation of the cancellation under section 30. They have not sought revocation of the cancellation.
That will not happen, Mr. Rahman. There must be a limitation period for
Yes, there is. That's beyond the period. And even they have not preferred any appeal.
But where will small vendors go?
Yes, your lordship.
In the case that has been cited here, there was an appeal preferred, but in the appeal was dismissed. Here, no appeal has been preferred.
This hearing was granted by Justice Abhinav, page 20. Fine, in the same circumstances, same set of facts, non-filing of returns for the past 6 months.
All right, take down. The petitioner has preferred the present writ petition challenging order dated 27. The date of the order 27/1/2022. Passed by respondents whereby the petitioner's GST registration has been cancelled with retrospective effect from 1/12/2020. Full stop. Learned, Miss So-and-so, what's your name? Miss Khushi Kundu, learned counsel for the petitioner, states that the GST registration was granted to the petitioner with effect from 1/7/2017. Full stop. On 18/7/2018. On 29/11/2021, Ashoka's notice was issued proposing the cancellation of the petitioner's GST registration on the ground of non-filing of returns for a continuous period of 6 months. Full stop. No response has been preferred by the petitioner and hence wide order dated 29/11/2021. The GST registration has been cancelled with retrospective effect from 1/12/2020. It is the submission of the petitioner that the petitioner got to know of the said cancellation only on 25/2025. Full stop. Hence, the petitioner has preferred the present writ petition. Learned counsel for the respondent states that the petitioner should prefer an appeal, a statutory appeal,
Under section 107.
under section 107 in terms of the cancellation order, full stop.
Petitioner may also seek a revocation within the.
Sorry,
Could have also sought for a revocation within the time.
it is further stated by the learned counsel for the respondent that the petitioner could have sought for revocation of the said order.
Revocation of the cancellation
Revocation of the cancellation, cancellation of
in
GST
accordance with section 30.
in accordance with section
30.
13, full stop. Learned counsel for the petitioner has, this court has heard the argument advanced by the counsel for the parties. Learned counsel for the petitioner has relied upon order dated 9/4/2024, right? 9/4/2024, passed in MAT number 639 of 2024, passed by the division bench of this court, and by ordered and an order dated 28/4/2025 in WPA number 996 of 2025, full stop. The division bench of this court in similar circumstances in MAT number 639 of 2024 had set aside the cancellation of the GST registration, full stop. The relevant portion of the said order reads as follows: 3, 4, 5. Take to take page 21. In view of the judgment passed by the court in MAT number 639 of 2024, the present writ petition is allowed, full stop. The impugned order is cancelled. The impugned order is set aside subject to the condition that the petitioner will file the returns for the default period and shall also pay the requisite tax, interest, penalty, and any other charges, if any,
Fine,
within a
fine.
period of,
Yes.
any other charges,
Yeah, yeah.
if any, within a period of 4 weeks, within a period of 4 weeks, full stop. If the petitioner fails to comply by the said direction, the present order will have no effect, full stop. The respondents are directed to open the portal for enabling the petitioner to for filing, to file the, enable the petitioner to file the return and make necessary payments in accordance with law, full stop. With the above direction, the present writ petition is disposed of.
Grateful.
26 and 27 same.
25.
Item number 25.
Just, Ms. Khushi, just do one thing. Give in item 26 and 27, you just note down the dates and hand it up.
27.
Just a minute. I'm not passing any order. I'm just asking you to make a note.
Okay. In this matter, I heard the view of this honorable court regarding the jurisdiction part.
Yes,
But in this matter, that respondent number 4,
yes,
with the inspector in their cyber crime jurisdiction cookie,
yes.
as per the request of that concerned police station, that respondent number 3, State Bank of India, refused the account of the petition.
File in the principal bench.
Yes.
There's a direction which needs,
The party that criminal.
whatever it is, sir.
I just asked for the only my prayer is that the amount in question, I will not touch it. Only I will give
Sir,
the liberty to.
all that action,
accept my account.
all that action has been taken in view of the Hooghly police, the directions passed by them.
Yeah, that's true.
File before the principal bench, get an order. All right.
Yes,
Learned
madam.
counsel, the petitioner seeks to withdraw the present writ petition with liberty to file the same in accordance with law.
Sir,
I'm grateful. Oh, I'm in 26 also.
Item number 26.
26, just give the details.
27.
27, I'm for the statement.
26.
Do I need to file the report, my lord?
27.
I'm just passing the same order. I'm allowing them, they will make the
Like-
payment,
Yes.
we'll allow it.
26 study.
These are small vendors.
Yes. Diplomacy. Yes.
26.
Item number 27.
Real.
27 same. You give the details.
Enough.
Item number 28.
28, Your Lordship, Mr. Kunaljit Bhattacharya.
And for respondent number 8, 9, and 10, private respondents.
He has his legs before the principal bench, and that's why he could not appear, Your Lordship. He's asking for 2 days. Mr. Kunaljit Bhattacharya,
What do you want, Monday?
Monday. Right.
Not today.
Grateful, Your Lordship.
Lordship. Lordship, can you take it on next week, Madam? And for the.
Lordship, we need a copy.
Your Lordship, service upon some of the response has not yet been effected.
When do you want?
Any day, next week. Any day next week.
Not today, Wednesday. In the meantime, you serve upon the
Lordship,
We
Monday.
have served.
Wednesday, what is the hurry?
We have served by post together with the annexure.
Whatever it is.
We did not receive.
Give a
Lordship, we are representing Gail.
And there are other respondents. Yeah, no Aligar. No Aligar.
Give a copy, give a copy.
Good.
Wednesday.
Yes.
What is it? 16. Great for us.
Wednesday is not 16, 16, 18.
Item number 30.
Lordship, I beg to appear on behalf of the applicant, Lordship. The applicant has been filed within time, Lordship. There is no delay, Lordship. So let give a direction to serve the copy and for preparing the informal paper books and let the trial court record be called for.
Petitioner has preferred an appeal against judgment dated. What is the date of the judgment?
Judgment 4/4/2025.
Petitioner preferred the present writ petition against the judgment dated 4th April 2025. Full stop. Passed by the MACT. Passed by the Motor Accident Claim Tribunal. Learned counsel for the petitioner states that the award, the judgment has been passed in contravention to the settled principles of law as enumerated in Sarla Varma.
Sarla Varma Pradashakti.
In Sarla Varma, give the citation, and Sarla Varma versus Delhi Transport 2009 6 SCC and National Insurance Company Limited versus Pranay Sethi 2017 4 TAC 673 SC. This is your contention, right?
That's for the enhancement of the award.
Enhancement of the award. Let the trial court record be requisitioned. Informal paper books be prepared. What is the system here? Informal paper book. Informal paper books be prepared. Tamal dekh lena hai.
After the arrival of the trial court report. Department.
Trial court record be requisition formal.
Intimates us regarding the arrival of the report and we submit the form.
Both same.
Within time.
Memo appeal needs to be classified in words as one preferred from original order.
Actually, I will remove the.
Remove the defect.
On Monday, not.
Monday.
Monday.
Monday, this one Monday.
Grateful Lordship. Not kindly make it Tuesday. I will not be available Monday, Tuesday.
Tuesday.
Grateful Lordship.
Tuesday, you have the other matter also.
Lordship.
Lordship, praying for one day accommodation.
Not today. Why? What happened?
Lordship, learned senior counsel, his mother is not well, that's why.
All right.
And out of petition. My lord, my humble prayer in preference of the order passed by the Honorable Jasmine District Bar on April 28.
The report.
Directed the BI of.
Just a minute. Yes.
There was a direction to submit a report in the form of affidavit, my lord. This is the one. Submitting the same, my lord.
You have got a copy?
Yes.
I
He has got
submitted the reply of the.
Report in the form of affidavit is filed by the state. The same is taken on record. A reply to the same is filed by the exception to the same is filed by the petitioner. The same is taken on record. Full stop. This is a hearing matter.
No, it's not a hearing matter, my lord. There was a direction to approve the panel, my lord. But there are certain difficulties which is being faced by the DI to do the same, my lord. And that is stated in this report, my lord. There is an unavailability of testimonial asked from their end, my lord, as because the papers are stolen. There was a direction on the school authorities to supply the testimonial, but they said that that has been stolen. And
let me understand the case, madam.
Yes, madam.
Yes. Yes, sir. Tell me.
Yes, sir. Just a minute.
This case is.
This case
The
is.
signatory of the previous xeroscopy of the panel and recursive on empty is found in different.
Sir, where are you reading? First, tell me your case. What is your case?
Case is that the DI of school Jalpaiguri to take steps for approval of the panel, submit the report before the court on next date of hearing. But till date, the order is not implemented, which is passed by the Justice, Honorable Justice, which is also on 28/11/24. The learned advocate of the state respondent are notice and explains necessary way as per the order passed by the Lordship of the Honorable Justice Amrita Basu and has submitted the reply of the affidavit.
Sir, can you please take me to the what have you filed this? What is the writ petition all about? What are you seeking?
Seeking the this circumstance data about the petitioner most humbly says that your Lordship made graciously pleased to pass order to approve the recursive panel wherein the petitioner has start the first position. Secured first position. Here of school Jalpaiguri send the approved recursive panel of the school authority of the Calcutta High School, Post Office New Calcutta, District Darjeeling with the direction to issue appointment letter with the direction to issue appointment letter. Appointment letter in favor of the petitioner as per the recruitment rule. The school authority adding the marks of the BA in the credit of the petitioner of the approved panel of the DI.
Kindly come to page number 30, my lord, of the writ petition.
And the petition.
There is an elaborate order, my lord. Your lordship goes through the order, my lord. My lord will come to know about the fact of the case, my lord.
the position of the panel updated of the petitioner from third position to first position and the recurrence panel submitted to the clear of the
একটু দাঁড়াও পড়ছি পড়ছি।
Yes, sir.
This is a checkered history, huh? Going on since 90.
Yes, my lord. And thereafter they filed a contempt application, my lord.
8 years.
28 years.
How old is the petitioner now?
She's going 59.
15. First 97.
How old is the petitioner today?
It is 24.
She's 59.
59.
And what is the retirement age? 60?
60.
Very good. Excellent. Yes.
My lord. Thereafter, they filed a contempt application, my lord, and there was a revised panel, and in which the present petitioners secured the first position. And what has happened now? They are filed this writ so that as per the revised panel, she may secure a job. And for that, this writ has been filed. Now, what is the problem in hand, my lord? That the DI is facing, because there's a direction on the DI to act accordingly, my lord. But the DI is facing is that the testimonial of the empaneled candidates have been lost by the school authorities, and he doesn't have the same, without which it is not possible for him to give approval to the panel, my lord. And not only that, my lord, he is also facing certain other problems in approving the panel, my lord. And which is stated in my report itself, my lord. The report which I filed, my lord. That's page 4 of my report, my lord. My lord, it says the 1, 2, 3, my lord. The problem he's facing. He's saying the paper submitted by the school authorities is found not in order. And beside that also, my lord, he has written something, my lord. Okay.
No, this direction was given long back. Today, for the DI to raise all these objection,
My lord.
it's too late in the day.
My lord, my lord, you have to approve the panel. For this, he requires such documents, my lord. That is what he's saying.
No, madam, this order, the first order was passed when? For the DI,
15/10/98. Panel was approved by the DI with verification of the records. And the same panel discussed by the school authority and submitted to the DI for approved.
when was the first order passed for the DI?
My lord, to comply the said order, it was sent on the school. The school has sent it on 5/2/2024. That is in page number 40 of the writ petition, my lord. Page 40. Writ 40. Writ petition.
Page 40, huh?
Page 40. School lesson.
So this is the panel prepared by the school.
Right.
Then what happened after that?
They did not send the testimonials, my lord. We had seeked for that, my lord, and thereafter they said that it has been stolen,
Where have you sent the letter for the testimonial?
my lord. ওটা তো রিপোর্টের মধ্যে পাঠালাম। রিপোর্ট আছে এটা। It's been showing the- My lord, we had earlier submitted a report, my lord.
Where is that?
Dated 19/12/2024, my. It's in the record, must be in the record. Can I submit? এটা একবার এটা আছে আর একটা copy?
Something to do earlier also.
No, 44.
Have you written to the candidates about the testimonials? They can provide you the testimonials.
My lord, the school is supposed to provide the testimonials, my lord.
That's right, but who appears for the school?
They are appearing.
Yes.
Yes, have you written?
No. We have already appeared before Justice Joy Shagupta and has submitted our complication, the matter. What of the problem? During that. Order dated 3/3/2025, my lord.
We are directly to appear in person with delegate lawyer.
We appeared and produced the documents.
There is theft in the school.
No, the order that is being written there, no matter. I'm going through the order that passed by Justice Joy Sengupta, my lord. Learned Council,
Just a minute.
Learned Council appearing for the.
This is 3rd of?
3rd of March, 2025.
Just before the other.
Yes.
পড়ছে।
Yes.
Yes, my lord. The matter is that head of the institution, we are on behalf of the fifth and sixth of the respondent, presence of the client, they were present there before you, my lord. The present headmaster has joined this institution only 6 months ago. Much before that, there was a theft in the school. Some of the relevant records have been stolen. The headmaster has already sent the available records to the district inspector as per direction. This is the matter. The documents and the materials that we produced, and that has been sent to the district inspector of school, and the document that GD made during the time by the that is their school authority.
Sir, you can't make a person run from pillar to post. The school authority, if they don't have any document, they should have written to the
District
other,
inspector of school, yes.
not district. They
Then-
should have written to the qualified people. There are three impaneled members, right? Three impaneled, who all are there?
My lord,
There,
petitioner's testimonials are lying with the each petition. Other two candidates of the panel exceed 60 years. They have no claim for the.
That is over.
that we cannot say, that they have got no claim out.
See, you can't just make the petitioner run from, just a minute, sir.
Yes, sir. Relevant paper I enclose with my.
Just a minute.
Please,
Relevant paper.
please.
Wait.
What my lord is saying. Yes, my lord.
You can't make him run from pillar to post. You're just trying to delay it, nothing else.
No.
Finding ways and reasons to delay it.
My lord, not dealing, yes, because the Division Managing Committee, they filed that GD to the police station, that all papers and documents has been lost.
You could have written to the.
Yes, written to the
the
district
candidate,
school.
the candidates. They could have provided you another copy of it.
The candidates are not available.
What do you mean the candidates are not available?
How they are, my lord, I have. got that-
Candidate is here?
No. Only candidate that petitioner is present here.
Two more candidates, you have all the details of the candidates. There's a panel which you have created.
The testimonials, the documents
Sir, testimonial and document is of whom?
of,
Candidates?
yes, candidates.
Who are the candidates?
Those
Who are
who-
in the panel?
They were in the panel among the 22. 22 appeared before the interview.
What is the selected? Only three?
Only 3. Panel was made,
Of only three
Composite
members?
three.
Three candidates?
other 2, they are not present here.
Doesn't matter. How does it make a difference if other two are not present here? This is for you to send the documents which you say got gutted in the fire or theft, whatever it is. You could have asked for the candidates to supply you a fresh copy or certified copy.
Then we have to call for the those 2 candidates.
Yes,
These
you
are
have
not
to call-
available at present.
Absolutely, you have to call for it.
The school authority, my lord.
Who will call for it? The school authority itself will call for it and then supply it to the director of schools, district inspector schools.
If it is our duty, then let there be any direction, my lord. Then we will make contact to them. They will have to supply, as because already the petitioners, on behalf of the petitioner, said that their age has been exceeded.
Yes. Record is there. Their date of birth
We
is
have
there.
got no complication. Date of birth, that is a different thing. But the testimonials.
You have supplied the testimonial to them?
Yes, along with the year. Date and one more copy is lying with me. If they require, I will give it.
So now since the other two candidates are out of the selection process, Miss Sarkar,
Yes, ma'am.
now since the other two candidates have crossed the age
My lord.
of selection,
My lord.
he is the only person
Person.
concerned, then what is the difficulty?
My lord, direction may be passed, my lord, in that regard, my lord, the DI will comply, my lord.
Why the DI is not complying with that?
On the other petition. My lord, there are two documents is annexed in this case, my lord. Is he talking about this annexure P1? These two testimonies.
It's a petitioner document.
My lord, if a direction is given that considering this testimonial which is annexed to the writ petition.
Where is the testimonial?
Testimonial, Chair.
Here in the writ petition, sir.
Petition page number.
Let him supply the copy that which was supplied, furnished by him at the time of.
Let us see if it is here in the writ petition.
No, also two of them, those are in the panel. সেটাই তো কথা, ও নয়, যাদেরকে কল করে, let them call. Otherwise panel cannot be prepared.
This except P1 and.
না, না, এটা হবে না, উনি দেখবেন। আমরা কেন বলবো? ছেড়ে দাও। No need. করবো।
Page 23, 24, Annexure P1.
23, 24, yeah, 23, 23.
22, 23, 24.
24. An order.
Not 24. 22, 23. Page number 22, 23. Annexure 1.
Which was the earlier order which was passed giving the direction to the director, director schools? Which order is that? Where you have filed the affidavit, madam? Where's the order?
But the earlier order was passed.
Sir, order.
Where is the direction passed to the director school, the district inspector school? Which order is that? The DI school has been given an order, right?
Revise my lord, that is in page number 30, my lord, 27, 2005, that order, my lord. For recast the panel. Managing committee.
So you have filed this, you have filed this affidavit in terms of which order?
That report, my lord.
Yes.
That was that, why was that panel, the recast panel was not being done? Oh, acha, that order, my lord, that is.
Order of justice on this sheet. Or this on. Master. এই তো, না এটা।
Order dated 23rd April 2020. Last one.
No, this is not the order.
এটা না, এটার আগের। এটাও না। Not this one. Not this one. Not this one. না না, এটা না, এটা। এটার আগের বিশ্বজিৎ ডাইরেকশন, বিশ্বজিৎ বাসু। এটা না, এটা না। এটা তো এফিডেভিট দিতে বলেছে। না, ওই যে অর্ডারটা যেটার উপরে রিকাস্ট করতে বলেছে সেটা। এটা ওইটা আর এটা।
My lord, it is.
না। হ্যাঁ, রিপোর্ট দিতে বলছি। এই তো বিশ্বজিৎ বসু, অনিরুদ্ধ, এইটা আছে। এটা ডিআই থেকে আমাকে দিয়েছিল।
Take down. The affidavit has been filed. What is the reply in the affidavit?
দিচ্ছে দিচ্ছে দিয়ে দিক কি বলে থাকে শিওর হ্যাঁ
The order dated 28/11/2024.
PS1
No, it is
তার আগে
28/11/2024 निकालो।
ছেলে
And the district, take down. The district inspector of school has filed a report in the form of an affidavit. In compliance of the order dated 28/11/2024, wherein direction was passed to take steps for approval of panel and to submit a report before this court. Full stop. A report has been filed dated 21/3/2024, 2025, wherein the district inspector had indicated that he is not in a position to approve the panel submitted by the school authority due to the following inconsistencies. 1, 2, 3. Yeah, it's page 4. Okay. The grounds taken by the DI school seems to be frivolous and shows that he is not inclined to exercise his wisdom on the facts which are evident from the record. The ground that the school authorities have not been able to send the credentials and testimonials of the selected candidates and that the same were lost in theft can't be a ground not to decide, not to take a decision on the approval of the panel, since among the 3 candidates, 2 have already attained the age of superannuation and are no longer in the race for the said position. As far as the petitioner is concerned, the testimonial of the petitioner are annexed here with the writ petition. And the director of schools can always verify the same from the concerned authorities. Full stop. The other grounds raised by the director of schools, district inspector of schools, can also be verified and decision can be arrived at by the district inspector schools for approval of the panel. It is hereby directed that the district inspector of schools shall comply with the earlier order passed by this court and file a shall comply with the order passed by this court, earlier chodo, by this court, and shall decide the issue of approval of panel submitted by the school authorities within a period of 2 weeks and file a report before this court. Full stop. It is sad to note that despite an order passed by this court on 25/7/2005, the 2005 order, right?
Right.
Where is that page?
Page 30. Page 39. 2005, 27, 2005.
That despite 2005, the selection committee, the panel has yet not been, selection committee, the panel has yet not been approved, and that the district inspector school has been dragging their feet for almost more than 24 years?
28
years. 28 years. 28 years. The petitioner is already at an age wherein she would retire within a year, and that the litigation fought by her for the last 28 years will not be fruitful. In the peculiar facts and circumstances of the case, it is expected that the inspector, yes, district inspector of school, shall without any delay decide the panel, shall take decision on the approval of the panel within the time specified by this court. Full stop.
Okay.
Let this matter be listed after 2 weeks. It is further directed that is the point. It is also made clear that that I've already said, I'll improve on it. All right, 2 weeks. 2 weeks next available, sir. Sorry?
Okay, but supervision orderটা implement হবে তো?
হ্যাঁ, report দিতে বলেছে।
Report, I've asked them to give.
The order will not be here.
That's what I have said,
তোমার
to comply with the order.
তোমার সেবারই দিয়েছি।
Let us see, hopefully.
Copy submitted there after.
I've recorded that copy as
There was an extra report we have submitted by relied by us if it is required later on.
The top is page. Yeah. Yes.
Great.
Page 4. Yeah. Give us 3 years. 1, 2, 3. Yes.
I beg to appear on behalf of the Madrasa board. Lordship has directed the Madrasa board to file a report. My junior will hand over the report. And Lordship may kindly peruse paragraph 3 of the report. The Madrasa authority was asked to submit the up-to-date audit report, wide number of office.
Where are you reading? What are you reading, sir?
Lordship, just as your Lordship has directed me to file an affidavit, a report in the form of an affidavit, and my junior has probably handed over the same to your Lordship.
Which was the last order by which you had been asked to file affidavit?
Your Lordship, was your Lordship's first order, I guess.
1st May 2025.
Which order, sir?
1st May 2025. Previous last date of the 1st May 2025.
Sorry, you're not audible.
Lordship,
Not today.
7 March 2025. 7 months, March 2025.
Will you assist? Because he's not audible.
Yes, Lordship.
Yeah, Lordship, he may assist. 2020, 7th March 20.
What is this writ petition? What are you seeking?
Lordship, the crux of the matter is the
Yes.
petitioner filed this this writ petition just to set aside the order of the managing committee, as the managing committee itself has not been accorded sanction by the Madrasa board. So how come a defunct managing committee issue a show cause and thereafter they can
Show me the report. Where is the report?
my report, your Lordship, because Paragraph 5, your Lordship, in the circumstances, the approval of the managing committee of Kalamati High Madrasa District, Kuchbihar is lying pending as unapproved for lack of up-to-date recognition.
Yes, Mr. Rahman. It has not been approved.
Your Lordship, it has not even been approved.
You appear for the Madrasa.
No,
Lordship, I am appearing for the Madrasa, Lordship.
It has not been approved by the Madrasa.
Lordship, by the Madrasa board.
So the allegation of the petitioner is correct that
Lordship, it is correct. And as such, I request your Lordship to kindly appoint an administrator, because in the lack of any authorities, so it is the appointment of administrator is a stopgap measure, whereas he may facilitate for the election.
who are the private respondents? These respondents who are part of the Madrasa, where are the office bearers? They have not appeared. Respondent number 6, 7, 8.
Lordship, office bearers, they have got no sanction. because the managing committee
Whatever
itself.
Whatever it is, are they appearing, not appearing?
Not appearing, Lordship.
Not appearing, Your Lordship.
They have been served.
They are not appearing.
They have been served.
Yes, yes. Yes,
Have you
my lord.
served them? Why should I appoint anybody, Mr. Suleiman?
Lordship.
This is a hand in glove affair of both of you, nothing else.
Lordship, I am the board, Lordship, because they conducted an election.
All right, so he's only asking for setting aside. Your
No, they
affidavit has
My
come.
lord, the issue is the suspension was made by a committee which has no authority in law.
Yes.
Rightly, wrongly, my lord, kindly visualize. My lord, a committee authorized by law has
Mr.
to
Bhattacharya,
take
Mr. Bhattacharya,
steps.
first of all, tell me the facts of the case.
My lord, the petitioner before your lordship was placed under suspension.
All right.
You know, the suspension order, which has been issued by the managing committee of the school, is under challenge in the writ petition.
Which page is the suspension order?
96. Page 28 of the writ petition. Annexure P8. Annexure P8. Milord, the letter kindly sees, Milord, 12th of January 2025. Now, this, we have questioned the jurisdiction of these persons to place the headmaster of the school under suspension. Because, Milord, according to us, according to the writ petitioner, the case built in the writ petition is that the managing committee has no legal basis, inasmuch as it has not got the approval of the Madrasa authorities, the board.
Madrasa board.
Milord, the matter was previously carried to your lordship's court. Milord, in fact, the previous order of your lordship's court, Milord, clearly indicates that if the managing committee has not been constituted in accordance with law, then any steps taken by it is void ab initio. Madrasa Act. And I am relying on Rule 8 of the management rules of pertaining to madrasas.
Who are these gentlemen who have passed this? Amaruddin Sheikh. You are saying that you don't recognize?
Milord, they are self-proclaimed, Milord, secretary and president of the managing committee, which has no recognition in law, which has no approval in law. Milord, kindly seize my pleading in paragraph 19 of the writ petition. And Madrasa, Milord, paragraph 19, page 9. Madrasa boi ache samne.
করতে জানিনি বই কোর্টে যাচ্ছে সেরেস্তাতে রাখা আছে Sure.
Mr. Suleiman, Mr. Rahman, how can you say that you don't have any authority? The state would be looking into it.
Milord, Mr. Suleiman is appearing for the board.
Lordship,
Yes.
as per your lordship's direction, I have filed a report today, your lordship.
I don't. Yes.
As per your lordship's direction, I have filed a report today. Probably my junior has handed over the same to your lordship. And as per my report suggests that the managing committee has not been accorded sanction by the board, Madrasa board, because they had to supply certain documents which till date they have not yet supplied. Like which one of the very vital important thing is the audit report, which they have still not yet filed. And as such, the managing committee was not accorded sanction by the Madrasa board. So our question is, how come how come a self-proclaimed managing committee
Who had appointed the petitioner?
Milord, the managing committee, erstwhile managing committee, whoever was there.
There is the letter.
By the commission, on the recommendation of the commission.
on the recommendation
By
of
the
the
Madrasa Service Commission, Milord, page is page 25. Page is page 25. On the recommendation of the commission. The Madrasa authorities appointed me on the recommendation of the commission, Madrasa commission, and my service also stood approved.
This is 2025, Mr. Approval of appointment. When is that?
Well, approval of appointment is page 25, 14 November 2011. 14 September 2011. Page 25.
Office of the District Inspector of School.
Yes, that is, Milord, kindly, Milord, pardons me. Milord, I am trying to assist your lordship. Milord, the Madrasa Commission conducts a process of recruitment. A person vying for any particular post in a madrasa participates in the process. On sailing through the process, Milord, there is a personality test, there is an interview, madrasa is chosen, ultimately he is recommended. Thereafter, on the recommendation.
Mr. Bhattacharya, the basic question is, when you're talking about the madrasa, there must have been a board which would have conducted this exercise.
Yes, the Madrasa board, but that is Mr. Suleiman's client.
Mr. Suleiman, where is the board?
Lordship.
He is the board. He is representing the board.
I'm representing the board. The crux of the matter is, Lordship, one person, he was appointed as a teacher in a madrasa. Thereafter,
Mr. Suleiman, how was he appointed?
He was appointed through the process of law. As we have got
law, that's what I'm trying to understand, Mr. Suleiman. What is the process of law?
Madrasa Service Commission. Lordship, the Madrasa Service Commission has been enacted, and an act was enacted as Madrasa Service Commission Act, under which he underwent the procedures. This gentleman, he underwent the procedure. Text was examination was conducted. He faced the interview, and thereafter his name was recommended. And on such recommendation, the DI school approved his candidature, and then he was serving in the said madrasa. Now the question is that this managing committee, the concerned present managing committee, it has got no sanction in the eye of law, because that is void ab initio, the managing committee. And they have suspended this particular person. Now, your lordship had directed me to file a report whether this managing committee has the sanction of law or not. We have never given this managing committee any approval, because for want of certain documents.
Milord, whatever be the reason, Milord, cited by the board, the fact remains the managing committee has no approval. What your lordship is desiring is page 22 first.
Page 22 is the recruitment.
Recommendation by the commission.
That was conducted by the West Bengal Madrasa Service Commission.
And thereafter, Milord, page 23 is my appointment. My joining is page 24 and my approval is page 25. But that is the process, Milord, how it goes on. I am on a very elementary issue, Milord. The issue is, Milord, suspension has been made, order has been issued by an authority who has no jurisdiction in law.
Right.
That is the thing.
If that is so, and if the board has given a report to that extent, my lord, the only consequence is, my lord, the order has to be set aside, and I have to be permitted to join with all on a pay protection and everything, because, my lord, apparently, my lord, previous submissions made by me in course of hearing is that, my lord, I have also not been, my lord, paid my regular allowances.
Take note. The presented petition has been filed by the petitioner, setting aside of the setting aside of the impugned resolution of the alleged managing committee of the said Madrasa dated 17/12/2024. It is the case of the petitioner. Learned counsel for the petitioner, Mr. Bhattacharya, submits that the petitioner was appointed as he was appointed as
an, my lord, headmaster.
As-
Just allows me, my lord. Yes, headmaster.
Initially appointed as assistant.
As a headmaster, permanent post of headmaster, my lord.
as headmaster in accordance with the West Bengal Madrasa Service Commission. His appointment his appointment letter was issued by the Office of the District Inspector of Schools on 14/9/2000
2020, 2011.
2011.
2011.
14/9/2011. His appointment was approved by the Director of Schools on
The district
sorry,
inspector of
District
schools.
Inspector of Schools, Secondary Education, Pooch, Bihar, on
14 September 2011.
11. Full stop. Since then, it is submitted by the counsel for the petitioner that since then he has been carrying out the duties of headmaster in the Kalamati High Madrasa High School.
In brackets, within bracket, that is higher secondary.
In bracket higher secondary school. Full stop. Learned counsel for the petitioner states that all of a sudden on 12/1/2025, on 12/1/2025, he received an intimation from the managing committee, which in its resolution number MC/01 of 2025, dated 11/1/2025, had issued suspension of the petitioner with effect from 12/1/2025. Had issued suspension letter to the petitioner 12/1/2025. Full stop. Learned counsel for the petitioner states that the letter issued by the alleged managing committee is per se void ab initio, since the managing committee is not recognized by the madrasa. By the madrasa, right?
Madrasa board.
Madrasa board. The managing committee itself is not recognized by the madrasa board. Full stop. He further states that the committee is an illegal self-proclaimed body acting under the madrasa board and has no teeth in law. Full stop. Learned counsel for the petitioner further states that the suspension letter dated 12/1/2025 is per se illegal and shall be set aside. Full stop. This court-wide order dated, which was that order?
Last order was 1st of May. The initial order, made by your lordship's court was in the month of April, or even before that,
That's what I'm asking. Which is that order, Mr. Rehman? Which is that order?
Just give me 2 minutes.
They were asked to file.
Just give me 2 minutes.
What is taking the report is the order dated 7th of March 2025.
7th March 2025, Your Lordship.
That is just.
Yes, 7th March 2025. 7th March 2025.
This court, by order dated 7th March 2025, had asked the Madrasa Education Board to file a report indicating if any such managing committee is in existence. First, the board respond number 4 has filed its report, which states that the approval of the managing committee of Kalmati High Madrasa HS District Court Bihar is still lying pending approval for lack of up-to-date recognition. In view of the stand of the Madrasa board, the committee which has issued the suspension letter is itself not recognized by the Madrasa board and thus cannot issue any order of suspension. Full stop. Since the managing committee, which has passed the resolution, itself is under cloud and is not recognized by the Madrasa board, any subsequent order passed by the committee itself is illegal and has no authority in law in terms of the, which act is this?
West Bengal.
Madrasa.
In terms of the West Bengal.
Management of, takes up page number 9. Management of recognized non-government madrasas.
Management of recognized non-government madrasa aided and unaided rules 2002
of the West Bengal Madrasa Board of Secretary, West Bengal Board of Madrasa Education.
Page number 9. Management of recognized rules 2002. Full stop. In view of the stand taken by the Madrasa board, this court has no hesitation in holding that the suspension issued on 12/1/2025 is illegal and is set aside. The petitioner shall continue to serve on the post of headmaster and shall be entitled to all salary and perks in accordance with
I'm grateful.
appointment dated his appointment. Full stop.
Along with all unpaid arrears, if it comments to your lordship.
Entitled to all his salary and perks in terms of his appointment letter dated. This the appointment letter is 28/1995. Page 19.
That is the initial appointment as an assistant teacher. As an headmaster is 30th July 2011.
Page number 22.
30th, page number 22. 30th July 2022.
30th July 2011, 2022.
2011. It's 22/6/2011.
It's 22/6/2000.
22/6/2011, not 30th.
6/2011. 22/6/2011 is the recommendation.
Yes.
My learned friend, whoever is assisting your lordship physically, may not perhaps.
30th/7/2011. 30th/7/2011. All right. With the above direction, the presented petition is disposed of.
We are grateful.
Grateful. Extremely grateful to you.
Rest of matters tomorrow. All right.
My lord, one matter, only extension is required. There was a direction for filing report by way of affidavit. I have prepared the
Who's the
affidavit,
petitioner?
but the concerned officer is ill, so it was not possible to affirm the same.
We'll take it up tomorrow. We'll give extension.
All right. Good.
আর পিটিশনার অ্যাডভোকেটের নাম লেখা তো? হ্যাঁ, তোমার নাম তো দিতে হবে, পিটিশনারের নাম।